his approach to the present contempt proceeding. We do not intend to proceed in the matter any further. The proceeding stands strong.
Benefits that are there from the amendment, Your Lordship. That is insertion of 4A and 4C to the.
You are appearing in 21583.
Yes, Your Lordship.
Have you checked if what
Yeah.
happened to the connected
Yes, Your
matters?
Lordship. I have checked the orders in the connected matters, Your Lordship. In the connected matters that was taken up on 9/10/2017, there has been a direction to connect all these matters with a single bench writ petition, that is 1593 of 2003, Your Lordship. Whereas reference has been that those cases have also been disposed of, and reference have been given to OJC number 3837, wherein the petitioners have been directed to go to the opposite party number 1 and be given a chance of personal hearing, Your Lordship. So, Your Lordship, may I provide you with
The
this?
virus of it.
So virus was challenged in that.
Your Lordship, the single bench petitions have discussed about the buyers being decided in OGC number 3837, Your Lordship. However, I was not able to get hold of that order, Your Lordship.
OJC,
OGC 3837.
why don't you pass the orders which you have? Why don't you pass?
Yes.
My lord, similar set of petitions were heard before the Honorable Single Judge, and those writ petitions. I'm sorry.
No, you don't have this order in case of Pramod Kumar Jina?
Here, my lord, the virus of the statute, although was not under challenge, but the Honorable Court decided and directed to grant the benefit. So far as the petitioner is concerned, he has only challenged the virus. So what I pray, my lord, if she drops the prayer for challenge of the virus, then the matter can be disposed of, keeping in view the order passed by the Honorable Single Judge. And the OP number 1 may be directed to consider her case in terms of the order passed.
No, once he drops her prayer for challenging the virus, then the matter will go to the learned single judge.
Yes, yes, that can.
That's
Yes.
Learned counsel appearing on behalf of the petitioner submits that they would not press the relief seeking declaration of subsection 4A of section 7C.
Yes.
7C.
Section 7C of the Odisha Education Act 1969.
Yes, Your Lordship.
Ultravirus, articles 14 and 16 of the Constitution of India. Stop. She submits that she will confine the to other reliefs sought for in the present writ application. Stop. Next. In view of the submission, let this writ petition, let the subject matter of, will you change that? Subject matter, you can change that.
Subject matter will be the same probably.
Same. Let
Delete
the,
that prayer.
Yes, Your Lordship.
let the relevant portion of the writ petition seeking declaration challenging the virus of section so and so be deleted. When will you delete?
Your Lordship, within 2 days. Within a day, Your Lordship.
by tomorrow. Can she do it here right now?
It is also in the stage of where they will incorporate in this that will be scanned and that is.
Once it is, it has to be scanned again. Right.
Can be treated to have been deleted. Okay.
Consolidated.
Huh? Okay. Stop. Let this repeat can be listed before appropriate bench assigned with the roster.
Much obliged.
Item number 2.
In fact, Milord, I am for the respondent number 1 read petition.
Well, I may be
In
allowed
the
to
case-
approve on VC. I am for the appellant.
Yes.
Item, I am for the appellant. And I have filed the appeal memo against the current single judge and Annexure 3 of the appeal memo. As per transfer policy, Annexure page 53, Annexure A by 1 to the counter affidavit filed by OUT. Respondent 1 was transferred.
Yes.
My lord, as per Annexure A by 1 to the counter affidavit, page 53. May I kindly see?
So let us see the order first.
Yes, ma'am. Now, order dated 22nd 8/23. My honorable single judge disposed of the page 2. On page 2, paragraph 6, second line, second part. The stand taken of the opposite part number 1 and 2 that the order of the transfer has been passed
What
basing
is
on the notification
KVKS?
issued by the
What is
University.
KVKS?
Krishi Vigyan Kendra. Man, that is Krishi Vigyan Kendra. 30 district
What is
in
KVKS?
KBK, that is Krishi Vigyan Kendra.
Krishi Vikas Kendra.
There are 30 KBK in the Odisha, all in the all districts. 30 districts for 30 KBK. Krishi Vigyan Kendra.
Just a minute.
Aap-
Just a minute.
Respondent was-
Please wait, Mr.
Yes,
Pat Joshi. Please wait for a while.
my lord.
Yes, where is the order of transfer?
My lord, as per page 53, as per transfer policy, Annexure A by 1 to the.
Mr. Please, please respond to our queries. Where is the
Yes,
order
madam.
of transfer?
The transfer order on the page 34, Annexure 4 of the read petition. Page 34.
All right.
Page 34. Application were received from,
Yes,
Mal
yes,
got it?
yes.
Please
Wait.
wait.
Oh,
This is the order of transfer. Annexure
Miller, and page 34,
Page 34.
the read appeal.
Annexure 4.
Page 3, come serially, page
Annexure. Page 34.
running page 30.
In fact, in the read appeal,
Mr. This order was under challenge, Annexure 4.
it is
All right, let us see. What is your name? Name of the petitioner?
that is Dr. Lata Malik.
Rathamali.
There and page.
Serial?
Serial,
His name found place at serial
24.
2.
24.
24.
24. Yes, ma'am.
so page 36.
Page
What
36.
petition tendered? What is it?
Transferred
Transferred and-
against post of scientist, land protection, KVK.
Existing vacancy.
That was the earlier one. Devgarh,
Transferred and posted against the existing vacancy.
vacancy arises on transfer of Sri Labba Soren.
So this order of transfer was issued on 4th July 2023.
My lord.
This transfer order refers to an application filed by the writ petitioner. Where is that application?
No application has made. Only as per recommendation of the transfer committee, as per transfer policy, the 71 teaching and non-teaching
We
staff
will not
are-
see the mister, we will not see the transfer policy. We will see the notification. Office order. Please come to,
As per transfer order, that has been mentioned on the recommendation of the transfer committee, the
Read
following.
that whole thing,
scientific-
please read that whole thing. 4th July 2023 office order, please read that order.
My lord, application were received from all employees of KBK under
All
OUT
is not
on
there.
transfer for the academic year 2023-24. Therefore, the transfer committee verified all the proposals on the basis of merits and administrative exigencies and decided to transfer the following scientists SMS of KBK. SMS means that is subject matter specialist. KBK is a Krishi Gyan Kendra.
KBK Noyagad to KBK Sambalpur.
To Sambalpur.
Noyagad to KBK Sambalpur.
How many years were you there in Nayagarh?
Noyagad for us 2.5 years.
2018.
18. 2018.
From 2018 to continue.
Not a premature transfer or anything?
I'm still there, but they are not allowing me to join in my work despite of order of this annual court, and they are not releasing my salary because on the plea that they have preferred a writ appeal where there is no stay order is granted. That I filed a second writ petition. In the second writ petition, I filed a IA for release of my salary. That was rejected by Honorable Single Judge, against which I moved to the Honorable Apex Court in SLP that I have annexed in my IA. Where the Apex Court has that both the matter be tagged together and disposed of expeditiously.
Now you can transfer. We have remained there for more than 6 years.
Milord, it is a general transfer, Your Lordship. It is a general transfer on the basis of the transfer policy, Your Lordship. The policy they have annexed. I am reading, Your Lordship, page 53. 53 I am reading. General transfers are ordinarily be made during the month of May, June.
See, those circulars are not law.
Milord.
All right.
Yes,
They are just guidelines.
yes.
So you cannot rely on the transfer policy. Transfer can be made against the transfer policy. All right. In administrative exigency, there is nothing wrong about that. Now let us see what to do about your salary.
Milord.
That is the only thing.
My
Transfer
submission
we-
is there before Lordship is that. Only my submission, Lordship. This transfer was made on the basis of their own notification. I have not submitted any application.
We
for my transfer.
understand that. He is also not saying that you had made any application. So where is that in this office order that because you made an application, therefore you have transferred?
Because that is I am reading, Your Lordship.
That we have read.
That 53, page 53.
Yes, please
On the
read.
basis of notification,
Yes.
general transfer ordinarily done during the month.
You are again reading this.
That 4 paragraph, Your Lordship, I am reading just.
You're reading the policy.
That notification policy, Your Lordship. General transfer shall ordinarily be made during the month of May and June. The employees oblique officers interested for transfer need to apply for transfer in proper format through proper channel during the month of March. Application which have not been routed through the proper channel shall not be considered. And I have not submitted an application.
So there is no doubt about that. No one is disputing.
On the basis, my lord, subject lordship, on the
See,
basis the transfer
suppose-
committee was formed.
See, suppose a person applies for his transfer to Cuttack. There is one post. And the committee decides that he should be posted at Cuttack because of some extraordinary circumstance. Then someone from Cuttack who had not made any application will have to be transferred considering that application. So it is not that your application was there. Are we clear now? And transfer is an incidence of service. Can happen anytime.
In fact, my submission lordship is that
No, we will not look into that aspect. Yes, what about the salary?
for
Mr.
1 year I am not getting
Just
My lord,
yeah.
Lawrence Civil Judge, after relief of the respondent one, Lawrence Civil Judge passed the status quo order. Status quo order on 12/7/23. Thereafter, it was disposed of on 22nd/8. After that, we have filed.
So when was the order passed by the learned single judge?
Since he has relieved. My lord,
In fact, we intend to initiate contempt proceeding against your officers.
No,
You
my
did
lord,
not allow her to
after
join
disposal
and you are
of-
not paying the salary.
No, my lord.
We are suo motu
She was
proceeding.
already relieved.
We intend
No,
to
my lord,
suo
she was
motu proceed
relieved.
against the officials.
My lord, she was relieved on 4/7. Transfer order was issued on 4/7. Also same day she was relieved. That has been annexed, my lord.
When was he relieved?
Relief order.
When was he?
Page 39. Page 30. My lord, page 39 is relief
Just a
order.
minute.
Page 39. Transfer order annex 4, page 34.
When was he relieved?
My lord.
When was he relieved?
4/7. 4/7. 4/7/23. 4/7/23. Annex number 6, page 39.
Just a
Relief
minute.
order.
4/7/2023, she was relieved
My lord.
when this office order was issued.
4/7 transfer order, that is transfer order, that is relief order. Same day.
Where is your date chart? Nothing in the date chart.
No, my lord, I have filed. only-
Writ petition.
All right, let's
only
understand.
the-
Okay.
My lord. Okay.
And when was the order passed by the learned single judge?
My lord, that is annex 3, your lordship.
12/7.
Extra 3.
My lord, page
22/8.
Status quo order was on.
page starting
12/7.
from page 62 of the writ appeal.
What is the date?
That is 22/8/2023.
12/7. That is disposal.
So you will not pay her salary.
No, since he has relieved on 12/7, at the time of the honorable single judge
And what
order
is the
on 12/7.
and what is the effect of quashing of the transfer order?
My lord,
What is the effect of quashing of the transfer order by the High Court?
after passing, we have preferred the appeal, my lord. Appeal is pending, present appeal is pending. We have preferred the appeal.
All
We
right.
have challenged the
All
order of the.
All right, we are initiating contempt proceeding against who is the Vice Chancellor? What is his name? What is the name of the Vice Chancellor?
My lord, we have already preferred an appeal. Appeal
We
disposal,
have
appeal.
understood your submission. Please tell us the name of the Vice Chancellor.
Name, let's say, but full name is not known to me, my lord.
Full name, you can inquire. You are sitting there. You can call her. Call him. Whosoever is he or her. See.
My register name is, I can say,
No problem.
register.
We are of the prima facie view that by not paying the respondent / writ petitioner salary consequent upon quashing of the order dated 4/7/2023. Order date, transfer order dated. The appellant have committed contempt of this court in as much as they appear to have disobeyed the order passed by the learned single judge dated
22/8/2023.
22/8/2023, passed in WPC number 21192 of 2023. Stop. Next, a plea has been taken on behalf of the appellant that the salary was not paid to the respondent. Salary has not been paid to the respondent from the date of passing of the sports order dated 22/8/2023 because present intra-court appeal was filed. Full stop. We take note of the fact that there was no interim order passed by this court in the present intra-court appeal staying the operation of the order passed by the learned single judge, which is under challenge in the present appeal. So stop. List this matter tomorrow when the Vice Chancellor, the Vice Chancellor of Odisha University of Agriculture and Technology shall be required to join online for this court to consider initiation of contempt proceeding for deliberate disobedience of this court's order. Yes, let him join.
The name of Vice Chancellor Prabhat Kumar Rao.
We'll see. We'll see.
Item number 3.
These Vice Chancellors should be removed.
Country also looked to the last order. Pursued directed the state 4 weeks time allowed for the purpose of filing counter, but no counter has been filed. Findings has been challenged. Also heard the matter. The last occasion on 10/4/2020.
I have taken instruction for filing of counter, my lord. It will take some time. Your lordship may give me 2 weeks.
2 weeks
My lord, I have discussed with the secretary of the school and mass education department.
by way of last intelligence. 2 weeks further time is allowed for the state to file counter affidavit.
The same matter as item 8?
Item 8.
No.
All right.
Item number 4.
Sir, I'm on the petitioner, and I'm at VC. This case, this writ appeal, this arises out of WPC 8829 of 2000. The case has been disposed of on 19th March 2014, and this writ appeal arises out of it.
So where is the order passed by this court?
The order of the single judge
Hmm.
court is annex. The annex.
Yes. Now, what is there in paragraph 10 of the order?
Paragraph 3 of the order says the petitioner in the writ seeks direction to execute.
10.
Para 10 says, in the instant case, admittedly there is a delay of 19 years of filing the writ petition. Further, the premium of the allotted land was not paid within the stipulated time. There is no material record to show that that the duly filled-in lease deed was ever produced for approval. Thus, no formal order was required to be passed for cancellation of the allotment. It stood cancelled automatically as, in terms of clause 5 of annexes.
Yes, we have heard you.
Sir, my contention is that the single bench court, considering the delay of 19 years, has relied upon a judgment of apex court, which is not found in the apex court database history.
All right, we will see. We will find other cases. There are other cases. Anything else?
Mr. Naik, are you making an allegation that that judgment has not been passed? This is the problem when you appear in person and you're not aware of the earlier decisions passed by this court or the Supreme Court.
No,
Because you are not able to find, you are saying it is not there in the, not available.
I searched the apex.
Unfortunate.
It is not. It is
You know
available.
about that order.
But the important factor I want to submit before this court is that
No
the-
fact.
the amount alleged that is not paid is being paid, and in the affidavit, the opposite party never says that the premium amount is not paid. The premium amount is paid. The only contention issue that was placed before the single bench court was whether the lease deed was approved, or whether the lease deed was approved for registration of the lease deed or not. That was the payment of contention. The payment of premium is not at all a contention, which is brought up
Yes.
in para 10.
All right, we have heard you. The apparent in person and what of this matter for orders on 2 weeks. 2 weeks. Judgment. Yes.
Item number 5.
First, we look to your lordship's order dated 25/2024.
Yes.
Lordship directed the State Council to take instruction on file counter, and the court expects, this is your lordship's order. The court expects that in the meanwhile, the opposite parties have considered the issue raised in the present writ application. The issue is that they have given the approval, they have given the appellation, the next meeting of the high power committee, the matter should be placed. But higher power committee meeting is not being held. As a result, 2023-24 now is going to be passed. Plus, we wanted that, in fact, the state council take instruction. If the high power committee meeting will be held, then position will be shut it out.
Yesterday, I received the telephonic instruction only. I could not get because of the elections, declaration of election and code of conduct, they could not constitute the meeting. So they require some time to hold.
How much?
The Lordship grant me at least 4 weeks time so that I can.
Day to day.
Here-
To appear in
here-
examination.
Here, my lord, the petitioner has been granted the permission and recognition subject to post facto approval by the high power committee. And subsequently, the institution has already received the affiliation from the concerned university also. So only the high power committee has to take a decision.
Now, suppose high power committee takes a decision against them, then we will take up the matter tomorrow, day to day basis.
Lordship,
All right.
Grant
will
me
take
some
up-
time so that.
No, every day. So tell your high power committee that the court will take up the matter every day till high power committee takes up the matter and decides this way or that way.
Lordship, grant.
Every day. No, this is not done. Ask your officers not to take high court proceedings so lightly. So we'll take up tomorrow, again, day after tomorrow, and then Friday, Monday, Tuesday, Wednesday, every day.
Lordship may
This is
grant me
not-
2 weeks
no.
time as last chance so that. I can-
Not even a single day. Let us see. Your high power committee cannot control the, and to some extent it has controlled the high court proceedings. We'll see. Learned counsel for the state informs this court that he has been informed telephonically that no decision on the point of grant of post facto approval.
Yes.
Post facto approval of affiliation of the
My lord, permission and recognition.
permission and recognition of the petitioner hyphen institution
Institution.
has been taken because there has been no meeting of the high power committee. So stop. List this matter tomorrow so as to enable him to seek further instructions as to when the high power committee is going to meet. Tomorrow, like,
Item number 6.
and the is expected that. All right, we will see tomorrow.
Item 6.
Your Lordship, the conducting counsel in this matter is attending his father, who is admitted in the hospital. Therefore, Your Lordship, I humbly pray that this item may kindly be taken up any day next week, Your Lordship.
Is it a PIL? No, just
Constitutional validity.
constitutional value. All right, when do you want?
Your Lordship,
When do you want? Tomorrow?
any day next week, Your Lordship.
As requested on behalf of the petitioner on the ground of non-availability of learned counsel who has to address this court for the petitioner, whom I'll list this matter on 1 week.
Item number 7.
May I please? Madam, in this case, I am an institution for admitting ANM and GNM students. I was, my students are getting training in the community health center in the Chandipada, in the Onugul district. When I requested that for better training, my students should go to the CDMO hospital, that is district headquarter hospital. The district headquarter hospital referred a letter to the director nursing to take a decision. That is Annexure 2, my lord. That's there. They have not taken decision till date. In the meantime, that Onugul hospital has been declared as Onugul DH, district headquarter hospital has been declared as a medical college with 1,000 bed. So there is no problem for getting better training. It is the future of the students.
You don't have any right.
My lord. No,
You don't have any right.
3 hospitals, they must give that admission affiliation to 3 hospitals, 3 institutions. But in the meantime, it is 1,000 bed. The limitation is 150 beds. So if there is 150 beds, they should give affiliation to 3 college school institutions. But now the medical college has been with 1,000 beds. There is no technical problem. I shall file a representation, let them consider that aspect, my lord.
You can pursue.
Yes, my lord, that is
File
the.
presentation. Give him a copy. And counsel for the petitioner, after some argument, seeks permission to withdraw this writ application with a liberty to pursue the issue which has been raised in the present application before the competent authority.
Right.
So stop. This application stands disposed of with the liberty as sought.
My lord, in the meantime, this may be noted, my lord, in the meantime, medical college has been declared. Onugul college has been declared.
You must have, they must be knowing.
They must be knowing, but they should consider that aspect. My lord's observation is, my lord's observation will be sufficient for me.
Not do that.
Item
You
number,
know everything, they know everything, they have to take a decision.
And they have not taken decision.
They have
That's
not
out for
taken
them.
a decision, then either you demonstrate that they are bound to take a decision
No,
under
no.
some statutory provision.
I will not,
We will surely do that.
I will not submit before my lord to that aspect, but it is my prayer.
If there is any statutory compulsion, yes, we are there. If you have right, we are there. But just representation, we will not do.
But in the meantime, that has been declared as a medical college.
All right, all right. All right. They will not, they must not have forgotten that there is a medical college.
Yes, but it is in the year of 2022. But that,
Oh, now 2024, they might have forgotten. Huh?
so I shall file a representation, my lord.
item number 8.
Please, Your Lordship.
Yes.
The government of Orissa, my lord, in the year 2000.
In fact, I am very sorry. Today in the morning, I read some other brief under the impression that I am reading your brief. Huh?
This is similar matter. That is similar or not?
It is
That
similar.
item.
One.
Five.
Huh? Item 5.
The government
Item
has-
3,
Hold on.
item 3, there also the virus of the statute
Three,
under
sorry.
challenge.
Yes.
Here also the virus challenged, but self-contradictory prayers have been made that claiming the benefit of the provision and at the same time challenging the virus of the statute.
But same statute.
Same statute.
So I might have read that.
Which
The
provision?
amendment.
Which provision?
My lord, 11(2).
It says that 11.
Can it come tomorrow?
Yes.
I'll see. I missed to see your.
I have read this. I will read it.
Uh-huh.
That is similar.
All right, because for your case, we will have to prepare ourselves.
But have you gone through your own prayers and understood what you asked for?
My lord, I will satisfy regarding my
Satisfy.
prayer.
And even if you don't satisfy, we will satisfy ourselves based on the records which.
My lord, I will try my best to
Oh,
satisfy.
yeah, we know. Everyone tries. All right. Tomorrow.
Item 9.
Yes.
May I? My
Yes.
lord, this question is filed challenging the inaction of the opposite party number 2 to 4 in restraining the private opposite party number 5 to 9 from making construction over the government reserve lands classified as gochar under Annexure 1, my lord.
What do you want? Removal of encroachment.
My lord.
What do you want? What is your prayer?
Our prayer is
But his allegation is that some private persons are constructing or making constructions over a gochar land. Ponda judgment mills.
Panda judgment is there.
Yes, there mills.
You can follow that.
Yes,
Trinath.
Trinath Ponda 3385.
Trinath Panda. Right. Follow that.
my
We have disposed of.
Item number 10.
It's all
May it please, my lords. Second journey of the petitioner, my lords, to your lordship's court. The prayer remains more or less, my lords.
Let this not be the last journey.
It all depends on your lordship's grace. Lordship's grace and munificence, my lords.
Which item?
My lords.
Yes.
Petitioner, my lords, was allotted a lease of my lords granite. Minor comes under the minor minerals, my lords, rules, concession rules, governed by the minor mineral concession rules. Now it fell due, even though the rules mandate that the minimum period for which a lease for granite can be granted is 20 years. Somehow the petitioner was granted, for whatever reasons not disclosed, for 10 years. So we signed.
Do you accept?
Malad, that we accepted. I'm not on also that. I'm on, my lords, a more innocuous prayer. That's a prayer for renewal, my lords. My renewal falls due, my lords, comes with a precondition that I should have had set up a factory, processing factory, my lords. Now, the petitioner, my lords, has filed several documents. He's also taken land, he has taken, my lords, the DIC registration and all, my lords, environmental clearance, and Pollution Control Board has given a consent to establish, my lords, certificate and all that.
But you have not established the factory.
I have, my lords, given some time. So it boils down, basically it boils down to the question was whether the egg comes first or the hen comes first. My lords, that it boils down to the, unless I have a lease, my lords, I'm not. So what I was only praying, because they have allowed others to function without my lords, setting up the factory. They've allowed others.
Have they renewed the lease of others?
No, they rejected me.
Others.
Yes, they have allowed them. One case was renewed also. And they have allowed several others, my lords. Everybody, almost everybody have filed those documents, my lords. Series of documents your lordship will find that they're all operating without, my lords, establishing any factory. Now, my application was, my lords, filed and kept pending for 5 years. From 15, I filed a renewal application well within time, my lords, in 2015. Now, that was kept pending till 2020, till the new rules come in. The amended rules come in, and then they consider my application under the amended rules. So my lords, so therefore, and much to my prejudice, because in the earlier rules, there are two things. One is my lease deed did not contain any such stipulation that you are being granted a lease with the condition, stipulation that at the time of renewal, you should be
in a position to have had set up a factory, and then only then it will be. But of course, my lord, there was a statutory a prescription in the statute, but that, my lords, in my most humble and most respectful submission, my lords, I'll demonstrate to your lordship that that's a directory provision. Under the 2004 rules, that remains as a directory provision. But under the 18 amendment, when the 16 an amendment comes in, 16 they don't touch it. In 18, my lords, amendment comes in, whereby, my lords, they introduce a rule 8A. Now, 8A, my lords, places it at a slightly higher pedestal than a, my lords, directory provision. So I have been rejected under a stiffer provision. And, my lords, and under the 2004 rules, Rule 8, Sub-Rule 7 of the rules, the statutory prescription is that it has to be, I have to apply for a renewal 3 months prior to the date of expiry of my lease period, which I have done. There's no dispute on this admitted position. And the application also, as per the my lords, Rule 8, Sub-Rule 7, has to be disposed of prior to the end of the lease period.
So
they don't do that.
Your submission is
My lords,
that because in some cases, law has been violated by some.
I'm not claiming negative equality, my lords. I'm not in that line.
No, because that has been violated. Therefore, the court should also violate.
So that's exactly, my lords. That is the reason, my lords, I made the submission that I'm not claiming negative equality, my lords. I know it in law it can't be claimed. Negative equality we can't.
We are not saying negative equality.
But
we are saying
I'm not
that because some authorities have violated according to you the law.
No, I'm not on that.
Violate.
No, I'm not on that. I'm not on that. My submission is different. My submission is you had to consider me under the old rules, the rules which were prevalent at the time of my application.
That question.
My lords,
We will examine that question.
that question.
It's a legal question we can
That's
examine.
fine. And that there is a judgment.
In fact,
also.
if lordship says
There is a judgment.
Just a minute. Yes.
Let me learn.
No, please continue. Please continue.
No, there is a judgment here. Paragraph 10 and 11.
Yes.
Delivered in the context of, my lord's, service jurisprudence, but nevertheless the principle should apply here. Paragraph 10 and paragraph 11. It may be that, your lordship, comes to paragraph 10.
Yes.
It may be that in a given situation, a decision of the state may be changed, but therefore, good and sufficient reasons must be assigned. The company failed to do so. The decision taken in this behalf smacks of arbitrariness. It prejudiced the candidates like the appellant. It is now well settled that ordinarily the rules which were prevalent at the time when the vacancies arose would be adhered to. The qualification must be fixed at that time. The eligibility criteria, as also procedures, as were prevailing on the date of vacancy, should ordinarily be followed. Now, this is one. And I'll just take your lordships to the rules. Your lordship, 2004 rules. 2004 rules. Lordship, may I kindly have that OMMC rules for a second, my lords? 2004 rules. Rule 8.
Yes.
Marks. Periods for which prospecting license, mining, quarry lease may be granted or renewed. 1. The period for which a prospecting license may be granted shall not exceed 2 years. The maximum period for which a mining lease may be granted shall not exceed 30 years. And there's a proviso to that. Sub-rule 2. Provided that the minimum period for which any such lease may be granted shall not be less than 20 years. So in 2005, my lease should have been there till 2025. My lords, which period I strongly submit before your lordship, my lords, would have been enough for me to set up that factory, my lords, because I was impeded for, my lords. One is, my lords, that for the Naxalite activities, my lords, and I've given in my show cause. Now, while considering my show cause also, my lords, the rejection order completely blindsides my show cause. Your lordship will see, my lords, sub-rule 3. A mining lease may be renewed for a period not exceeding 20 years. So I'm not praying here for 20 plus 20, 40. I'm only saying 10 plus, my lords, 20. As per the statute, my
10 plus 20.
10 is the initial period that they granted. 20, they have violated that statutory provision. I was entitled to a 20-year grant, initial grant of 20 years. So they granted me for 10 years. As per this rule,
So what is the date of the?
the date is, well, as lease is annexure 1, 2005.
29/3
March
for 2005.
2005. It should have been 29th March 2025.
Now
I'm sorry.
it was drafted in 2005.
No, I'm not saying, I'm not going there. I'm not going there. I'm only saying.
And when was your renewal rejected?
My renewal was rejected in 2020.
Annexure 8.
I filed the renewal application on 2015. I filed the application on 2015.
Why have you filed this petition in 2024?
24 minutes. I was bedridden. And there was difficulty, my lords.
23 writ application was filed.
23
It was
was filed.
rejected by your lordships. It went to the Honorable Supreme Court.
Supreme Court, it was
Supreme Court
dismissed.
confirmed the order. Now again, for the same cause of action.
Not
this
confirmed.
application-
I'll come to that. No, I have an explanation for that. Now, my lords,
But now you said you were ill.
no, that explanation I have given, I have furnished the annexure 10 documents to show that I was not well. Physically, I was
Then how
not.
did you file it in 23?
I'm sorry.
Then how did you file the earlier application if you're not
No,
well?
there that explanation was not given there. So therefore, I made good that explanation. That
So
was
you
the
are
premise.
seeking review of that order.
My lords,
You are seeking review of that order.
I'm filing a separate writ petition. No. I'm filing a separate writ petition on 2 reasons.
Is it a fact
My lords.
that against the rejection of?
I've given that. I've
Just
given
a
the
minute.
minutes.
Against that, you
Ma'am.
had filed a writ petition.
I had filed.
Is this submission correct?
It's correct. I've disclosed that. It's there.
After dismissal, you had gone to Supreme Court.
Supreme Court.
That was also dismissed.
Minutes.
What is the fresh cause of action?
Fresh cause of action is this, my lords. I'll just take your lordship to the High Court order. High Court order is this, my lords. Your lordship will find that page 181. Merits were not even touched by the Honorable High Court. (181). The effective portion, your lordship will find at page 182. Having heard learned counsel for the parties, after going through the records, this court finds that rejection of the petitioner's application was made on 15/12/2020. Therefore, if the petitioner was aggrieved by the said order, he should have approached this court immediately. Admittedly, the present writ petition has been filed on 20/10/23 after near about 3 years of rejection of the application of the petitioner. As such, for the delay in approaching this court, nothing has been pleaded in the application itself. Rather, it is contended that the application of the petitioner was pending before the government since 2015 and the same was rejected after 5 years, that is 15/12/2020, and therefore the delay and the laches which has been caused can be attributable to the state authorities but not to the petitioner. But the fact remains that though the claim of the petition was rejected on 15/12/2020, he approached this court by filing the present writ petition on 20/10/23, and as such, no reasons have been assigned as to why the delay has been caused in approaching this court. As such, in the case of Harendra Kumar Patnaik, this is, my lords, an exactly same case where, my lords, this honorable court had reasons
That
to.
order appears to be illegal. According to you, that order is illegal.
No, that order is the benefit
No,
is.
that order, the order.
Of the High Court.
Yes, it was rejected only on the ground. So therefore, the honorable division bench was unhappy that there was no reasons granted, and then they said that you are a fence sitter.
This is not a correct view.
Well,
That view is not correct view.
no, on the available facts that view, my lords, there was no explanation given at that point of time. So therefore, my lords, I could have.
All right.
My lords, I challenge that before the Honorable Supreme Court And the Supreme Court, my lords, condoned the delay and, my lords, dismissed the SLP, my lords. It was a non-speaking order, my lords, a cryptic order. Now, my lords, your lordship is aware of that coded distilleries case, my lord, that a dismissal of an SLP does not, my lords, by a simple dismissal simpliciter of the SLP does not amount to, my lords, a merger. So therefore, my lords, a review is also open.
Mr. Palis,
Well,
you are,
You've not filed a review.
this thing, you are giving us all legal principles.
My lords.
And how do those principles apply in your?
My lords,
Sir, this is a fit case where we should set an example how to stop filing of frivolous writ applications in the High Court. And we will do that in this case. And we will not allow you to withdraw.
No, I'm not withdrawing, my lords. I'm my lords, only on this point that after the dismissal of the SLP, my lords, I applied for in the RTI for, my lords, documents. Your lordship will kindly find the documents at Annexure 12. The RTI application is receipt is on Annexure 5, page 150, my lords, 54, 154.
Realizing that
My lord.
this writ application ought not to have been filed.
My lords, my prayer before your lordship is this, my lords, that I go with your lordship, my lords, on this one. No, it's an endeavor, my lord. But I could not. My lords, my contention is, my lord, that I received these documents later. What page documents under, my lords, annexure, my lords. I can, my lords, I can also review principles. Also, my lords, make. My lords, I can. Lordship may permit me to convert it into a review. I'll not join issues, my lords. I'll file a review. Lordship may give me the liberty to file a.
We could decide this circumstance in which it has been filed. We will pass an order, we are satisfied that this application. Exemplary law to set an example that in future such applications are not filed.
Can I only pray, my lords, that this is a.
After imposition of cost.
If your lordship is imposing cost, my lords, I have nothing to say, my lords. I would bow down and accept it. I have never, my lords, I am bound down and accepting it, my lords. At least the cause of action may be kept alive. But for a review on the legal, because your lordship may kindly the 8.7, rule 8, sub-rule 7. For a second, your lordship may come to.
Since you are insisting, we are again putting this question. After dismissal of SLP, or dismissal of verification, what is the best form of action?
Only the RTI application, my lords.
RTI application.
My lords.
RTI will decide will govern our decision.
No. RTI application, the information.
What information?
The fact that they have allowed others to function without. I should have, my lords. It's your lordship is. I leave it to your lordship how your lordship will treat this.
Yes.
Whether, my lords, my lords, if it's a.
We will write of this, how frivolous writ application should be handled by the High Court. Will be imposing exemplary clause in this case, to the extent that the person before filing frivolous writ applications have that sense of deterrence.
I would only pray that your lordship may not do it in this case.
We do
The man is already, my lords. At least your lordship, my lords, I bow down to your lordship, my lord. If it's a wrong advice.
Cost will not be less than 5 lakh.
If it's a wrong advice, your lordship may.
See, if a patient goes in the hand of doctor he may die. Otherwise, in case of, therefore, this will be larger.
Your lordship may permit me a liberty also for the review.
Item number 11. Yes, item number 11. I request my friend has not given a copy. So advance copy, it's let my friend give a copy of that writ application so that.
Let it come then next week.
Yes, anytime, Lord, let him give a copy of the writ application. May come anytime.
My lords.
11 minutes.
My lords, that is.
Or in that event, also may let them give a copy so that I can obtain instruction also. No.
Item number 12.
My lord,
12.
my lord, this is a PIL matter. My lord, the petitioners are challenging the illegal and forcible construction of community center in a reserved land of Bhagavat Melan Podia instead of the prescribed land mentioned in the project report, my lord. My lord, as per the Annex 2 is the project report, relevant person, as column 2, my lord, it has been sanctioned to sanction for
Mr.
the
Patnaik, so
village,
this government is constructing.
my lord.
This construction is by the government.
My lord, government, but project report is sanctioned for ward number 8 and a village Sarakona, my lord. That has been diverted and constructed in a different Mauja and a village.
Must be diverted. A decision must have been taken and then it must have been diverted.
Decision has been taken, my lord.
How can they do it without
My
that?
lord, further, my lord, it has been constructed in a Melan Podia, my lord. That is a reserved land, my lord, as per the Annex 3, my lord. And further, without inviting any objection from the villagers,
Seek instructions and then file a reply. Your lordship. Yes, your lordship.
my lord. Obliged.
Item 13.
This is a public interest litigation regarding removal of unauthorized encroachment from government land. The land belongs to, it is reserved for SSG groups for construction of the house for SSG groups. And the opposite part number 5, unauthorized encroach upon the portion of the land and constructed one residential house. And one inquiry was conducted by the
self-help group, my lord. Yes. And on being complained, my lord. I am the sarpanch of the concerned Gram Panchayat. Yes. And when inquiry was conducted under Annexure 2 Lordship Kyle Perus page 29, a notice was issued to the encroacher by the Tahsildar for removal of the unauthorized encroachment. Thereafter, the encroacher approached this honorable court in 2023 for settlement of the land in her favor. This honorable court directed that this cannot be settled and to directed the Tahsildar to take a decision in case one application is filed by the encroacher. Within 4 weeks, that has to be considered. But till that, Tahsildar is not taking any action nor vacating the land for construction of the house for SSG groups, my lord.
You're saying that court directed it cannot be settled, but even then said file a representation.
Lordship, kindly see
Where is the order?
The order I have given.
Page 30, Annexure 3.
Annexure 3, page 31, paragraph 5.
And OP5.
The order passed by this honorable court in the earlier writ petition filed at the instance of the encroacher, my lord. I have given the ROR. That plot is specifically reserved for SSG groups. And the encroacher is a government servant. He is working as a ASA member.
So this also directed for representation in respect of any other plot except this plot. Not that
say
same.
that.
Yes.
Paragraph 5.
Despite that, the Tahsildar is sitting over the matter without vacating the encroachment. And the Sarpanch specifically submitted a complaint, further complaint under Annexure 4. That is also pending. Tahsildar is not taking any action. She claims that she is a landless person, but she is serving as a ASA worker and her husband is a businessman.
No, this court has directed that that land can't be settled.
Yes,
So
yes.
she should not be continuing in that land.
And she is still residing there.
I'll obtain instruction in this matter. I'll obtain instruction.
May I request a short date may be fixed so that the construction is to be taken.
Item 14.
Item 14, I am appearing for the opposite party number 2 and 3. In compliance of order dated 12/6/24, that I am filing the counter affidavit. Yes. Yes.
May I may be pardoned to pray, my lords. Can this matter be listed day after tomorrow? Because the matter is.
Yes, Mr. Ram.
They are giving the count today. Can it be listed, my lords, day after tomorrow? Because my factory is closed.
Day after tomorrow. Instead of day after tomorrow, can you do it on Monday? We have some personal difficulty.
Yes. My friend has taken time on every occasion.
No, not every occasion. Last.
Granting time.
Yes, on 3 occasions, my friend has taken time.
Last, we are granting you time.
He is not opposing your.
Maybe taken on. No, I am not praying for time. Because he is filing the counter, he has taken time, he is filing counter. I am only correcting.
No, Mr. Das, do you have any problem if it is taken up on Monday?
The whole problem is the factory which employs about 5,000 workers is closed. Virtually is not working.
Your Lordship, the statement in 3 weeks' time, we need to file a reply also, Your Lordship.
Huh?
We need to file a reply also, Your Lordship. The statement.
Here I have filed the counter affidavit indicating.
No,
that
Mr. Das is appearing for whom?
I am appearing for the petitioner.
And you are for?
I am for the OP number 2 and 3.
I am for OP
I am
number 1.
filing the counter affidavit indicating that the allotment committee of the state government has refused to allot any OR so far the petition is concerned for the year 24-25. So now it is the state government to defend its own deeds.
So, Mr. Das, we will take up the matter on Monday. All right.
Obliged minutes for the whole difficulties. I was carrying my indulgence because the factory is closed.
All right, Monday. Today is Wednesday.
Yes, my lord.
We are going to take up the matter on Monday, and if the matter is listed below in the, then you can make a mention. We will take up the matter on Monday.
Yes, obliged, my lord, obliged.
As jointly requested on behalf of the parties, this matter on.
Item number 15.
May I please, my lord? My lord, this is a case pertaining to the mismanagement of the NEET examination, your lordship. My lord, in this case, the petitioner appeared for the NEET exam on 29th May.
No, but this matter has been taken up by the Supreme Court. This is the
Yes.
same issue.
No, here the issue is slightly different. Same mismanagement. They are before the Honorable Supreme Court, 3-4 issues are there. Bunch of petitions have been filed. All kinds of aberrations have been found. This particular aberration is interesting. Your lordship may kindly hear it for a moment.
You not provided a copy of your that OCMR.
My lord.
Yes, that is your grievance.
My lord.
Yes.
They have not. They on 29th they published the results, saying that anybody can challenge it by 31st May. Their scores, and they said that OMR seats are provided to the candidates. And I was provided the OMR seat only on 1st June, your lordship. That is after the 31st May deadline was over. They extended the deadline by 12 hours, that is 11 a.m. of 1st June. In any case, your lordship, the OMR link that they provided me didn't operate. I wrote to them that the OMR link that you have provided me is not operating. I wrote them thrice, your lordship. On 7th, they wrote me back that we're looking into it. And today we are here and they are not responding to it. I am not being able to follow it up.
It is not very. These things otherwise, see how many candidates appear in the such examination.
My lord, according to the data, it is 2 million, 2.5 million.
2.5 million. So if we start entertaining such grievances, then we shall become grievance redressal forum.
No, man. That it shouldn't be, but your lordship, in this case, the petitioner is scoring much higher marks. He has been given 209 marks, your lordship. Only he prays that before the counseling starts, which is 6th, his OMR sheet should be provided so that the marks can be matched. That's the only prayer, your lordship. That they are not providing. He has scored.
There was some cutoff. Was there any cutoff date?
My lord, but 31st was the date to challenge.
Challenge.
My lord, I couldn't challenge, though I have been given much less marks.
OMR seat.
My lord, because I have been given 209 marks, whereas I should be scoring 487 marks. I needed to verify that unless my OMR seat is provided, that cannot be verified, your lord. So that's the only the rank could be much more because I am scoring 487. They have given me only 209. And they're not giving me the OMR
How
seat.
do you say that?
Because my marking is mine. I can challenge that only legally only when I'm provided with the OMR seat. They decided the cutoff date to challenge 31st. They didn't provide me the date OMR sheet before that time. And when they did provide,
how have you calculated your marks?
Because student answer marks it on
we
his.
understand that, but how have you calculated?
That's what I'm saying. Because I have calculated, because I have ticked on my questions. I can verify that.
So you have stated,
my lord.
Have you made this statement in the writ petition?
Yes, my lord. At page number 5, paragraph number 9, I have said that in his own calculation, he should have scored 487.
No, that is not the way.
Right answer, all details unless they are there, your estimation may be anything.
My lord, all that can be,
All right, you file an affidavit.
my lord, I will file an affidavit.
See, and you will read. In that case, the candidate may be taking this risk.
My lord,
According to the
My
candidate,
lord.
he should have scored 487
my lord.
on the basis of the answers given by him
Yes,
and the model answers
Provided by-
available by the
my lord.
by the
My
NEET. This is your score,
My lord.
and then subsequently, if that is found to be untrue,
My lord.
then he'll have to face the
My
consequences.
lord. That.
File an affidavit.
There might be 1 mark, half a mark this side, that side, but 487 was over.
Half or
My-
1 mark, that is material.
My lord.
So
That,
the examination where the Supreme Court has said
Yes,
they
yes.
will be allowed to, I mean, the board has decided that they will take the examinations again. This.
no, the examinations again will be taken for those candidates who have been given grace mark of
Okay.
1 or 2 centers. That is the decision that has been taken, that
All right.
centers examinations will be scrapped, and those who have been given grace marks will be asked to take the retest, and those who do not take the retest will be assigned the mark before the grace mark given.
No, but that examination is
No,
not being
that's no connection.
No, that examination, that decision has been withdrawn. That decision to have the
Grace marks.
have grace marks,
Yes,
that has been withdrawn.
that they have been asked to appear the retest. That is it.
As requested on behalf of the petitioner, list this matter on 1B so as to enable him to seek instructions and file an additional affidavit to support the averment made in paragraph
9, your lordship.
Huh?
9, paragraph 9.
paragraph 9 of the petition. We'll see.
Obliged.
Item number 16. Here I filed an affidavit on so-called affidavit on 13th of March 2024, stating then that against that order, the state government has already approached the Honorable Supreme Court in SLP. That number I have also disclosed before Lordship.
Yes, your lordship. I am obliged, my lord. Your lordship has accommodated for a day. It was listed yesterday, my lord. In fact, today the SLP is no more, my lord. SLP is dismissed, my lord. That I am submitting the copy. They have to, they in their so-called affidavit, they say that give me some time, paragraph 9, that I'll adjourn the matter till adjudication of
When
SLP.
was it dismissed?
My lord, it was dismissed on, my lord, of 26th April 2024, my lord. I'm giving the article. By 3 bench of Honorable Apex Court. my lord.
What is the order?
Let's.
Did you comply with the order?
Yes, sir. Now it's come, the Lordship will grant me some time, and accordingly I will advise them to comply with the order for 15 hours.
What is BKD infrastructure?
Let's let it be that here BKD infrastructure is my lord, this is the leading judgment regarding retrospective operation of a circular. Your lordship has came across some judgment on this 7/6/2021. They made it applicable from 2012 in beginning on the vacuum period, and BKD was the recovery case. Here is a refund case, my lord. So here my case was recommended, but because of this circular, I am not getting. So it is covered by the principle of BKD.
Its contempt application has been filed, alleging non-compliance of an order dated 14/9/2023, passed in WPC number 31091 of 2021. So, in the show cause filed on behalf of the contemners, it was stated, so called affidavit, it was stated that and this SLP had been preferred before the Supreme Court, registered as SLP bracketed civil diary number 10789 of 2024. Full stop. Learned counsel for the petitioner has informed that the said SLP has been dismissed by the Supreme Court by an order dated 26/4/2024, a copy of which has been furnished to this court, which is being kept on record. So stop. List this matter on 4 weeks for learned counsel representing the contemners to inform as to whether this court's order has been, court's order dated so and so has applied to them.
Hello.
She came in person, you also directed online, but I said that she will be present, she is present.
But
But-
Mr. Samantray, when the court directs that she should be present, should you not ensure that she receives the communication at least over telephone, if not?
I think the communication order was communicated, but the staff did not bring it to her notice. And one more problem is that she joined recently. The earlier officer who was there, he did not only dispersal of representation. I ensured that she will do it within 2 or 3 days. She may call it exactly next week. I'll file the compliance affidavit.
A small thing, if you would have communicated, she would have disposed of also before coming to this court.
Yes, please, yes. Order, what is the order?
Order under Annexure 1.
Have you complied with the order?
No, so she has not complied. She backs on conditional approval, says that you'll also may call it next week. By that time, she will comply the order within day or two.
The Tahsildar Dhenkanal is personally present in court pursuant to this court's order dated 18/6/2024. Stop. She tenders unqualified apology for not implementing this court's order dated
20 February 2023.
22/2023, passed in WPC number 37072 of 2022. Stop. She assures this court that the said order shall be complied with by next week. Stop. List this case on Wednesday. So if by the next date, if on such and such date, the order is not complied with, they will be required to be personally present in court again. So stop. In the event she complies with the order, she shall not her personal appearance shall not be. All right.
One more prayer, Mills. In the present case, it's an encroachment proceeding. The petitioner is an unauthorized encroacher, Mills.
Petitioner.
Petitioner. And he was given notice to Mills to be evicted. He or she made a representation to the Tahsildar to consider for settlement of the land. In fact, there is a provision under the Act to make a statutory application for settlement that will be considered in accordance with. However, this all could be pleased to dispose of the writ application, directing to consider the representation, giving an opportunity of hearing. So may I pray, because Lordship granting 7 days time, let him appear before the Tahsildar within 2 days so that he can give the opportunity. Otherwise, it will be again violation of the Lordship's order.
When will you appear?
On Tuesday, madam.
On Tuesday. But he has to pass an order on Wednesday, by Wednesday.
Monday.
Monday.
Oh, that 8 day you are saying before the sub.
Exactly, Lord. But representation would not do.
That Tahsildar cannot consider, she has to pass accordingly then order.
Yes, lords. So,
That in accordance with the order.
Pass an order.
yes, that will do. But question is that the person has to appear, otherwise
That order has been.
that will also be direct.
That counsel for the petitioner states that the petitioner shall appear before the Tahsildar
Yes.
in Canal. In which office?
In office, Tahsildar.
Tahsil office
11 AM.
Yes.
for the purpose of for personal hearing
Yes.
on Monday.
26.
Did them.
Sorry, 24th.
24th, yes.
We give a time or not?
At when 10:30?
10:30.
11.
11 year also, yes.
11. In case the petitioner does not appear on the date and time as noted above, the date and at the time as noted above, mentioned above, the contender shall be at liberty to pass appropriate order based on the court's obligation.
Item 18.
What is the name?
Yes, I'm giving it writing. Yes.
Was the one who had been impleted is not there. Yes. The one who has been impleted, I don't think is
No,
there.
she has recently joined Millers.
Item number 18.
No, this case, lordships were pleased to direct me to comply the order by order 15/5/2024 Millers. And I have intimated them, but they because he has to be paid on the benefits in pursuant to the direction of the Honorable Court Millers. The director I have intimated, he needs some more time, Millers. Only a week's time he can comply with Millers.
No, what he can comply with the order after we convict him.
No, sir.
When was the order passed?
On 7/11/19.
7/11/19.
Yes.
So you are not required to comply. Even if you comply with the order, you will have to suffer. And why did you file this contempt application 5 years after that?
My lord, I have filed earlier, another contempt was filed. In that case, 4 months' time was
granted,
granted.
Millers.
It
It's a
was
second
not
contempt.
complied with. Once again, I have to.
Then we are proceeding against. Let an affidavit be filed by who had to comply with the order?
Opinion number 1, my lord, that is secretary.
Secretary.
Department of Secretary, opinion number 1.
If you also will look at this, the order was communicated by the petitioner to the superintendent of Odisha State Museum, Bhubaneswar, who is the authority. If you also come to page 12, Annex 2.
Yes.
No. What was the order?
My lord, order was, your lordship may kindly turn to page 11.
Yes.
Page 11, we have considered that aspect of the matter, and in view of the decision referred to above, it is directed that the petitioner shall be paid the differential salary of the promotional post for the period he worked. So that was the order.
So
who has to comply with?
Who had to comply with?
Yes. My lord, see, he worked under opinion number 2, Director, Department of Tourism and Culture.
To whom did you communicate the order? Where did you file the?
Earlier order was communicated to all. All. Three opposite parties are there. Earlier it was communicated to all, and recently after the second contempt, I have communicated to the superintendent so that it will be.
The order
Annexure 2 is you have given to the superintendent Odisha State Museum.
Second one in
so he's the one.
In 2019, this was given to the not recently. So only I pray he is the authority because he worked under the administrative control of the museum authority.
Yes.
He has to comply the order because salary shall be disbursed by him only.
Is he a party in this contempt petition? Is he a party?
He is a
Yes,
party.
opinion number 3.
3 is a party.
What is the post?
My lord, he what?
What is the name of that post?
Yes, post. My lord, that is
Library attendant, my lord.
museum at the OP number 3 or the person. He was library. He was in library.
Who has to pay? Who can pay? Who was required to pay you?
My lord, I am under the direct control of the OP number 3. And OP number 3, OP number 2 is
Superin-
the, my lord, authority.
OP number 3 is the superintendent, Orissa State Museum,
Museum,
Bhubaneswar.
Bhubaneswar.
Odisha
State Museum,
State Museum.
Bhubaneswar, Kalpana Square.
Museum টা কত
Bhubaneswar.
Huh?
Museum টা
লেখা
আছে ভুল লিখেছি।
So which post? This museum.
My lord, he is holding my lord, OP number 3.
Ah.
OP number 3 is the superintendent.
Superintendent. Let the contenders furnish the list of the names of all the officers who has personally who are holding the post of Superintendent, Odisha State Museum, Bhubaneswar. Since 7/11/2019. Till date, comma, there be allegation of disobedience of this court's order passed on 7/11/2019 in WPC number
WPC number
8484.
8484 of 17.
8484
Of 17.
2017. For this court to consider initiation of contempt proceeding against all such officers who were holding that post. This said post. So, list this matter on next Wednesday.
Yes.
All right.
Yes.
So in the meanwhile.
Yes, I understand, boss. I understand.
Oh, oblige me.
Item number 19.
19, your lordship, I have collected 13 matter. I have just passed in, but there are some other matter also, but if your lordship picks up this 13 matter, then rest will follow.
But we have to file one amendment because the order was passed pursuant to the interim order.
You may file letter, lordship fixing the date. In the meantime, you have filed.
Fixing a date. Final hearing. All right. So when do you want?
4 weeks. For the filing of the amendment and consolidated petition.
For final hearing.
4 weeks.
4 weeks. At 2 p.m.
Yes.
We have been informed. President Counsel appearing on behalf of the petitioner, and you are for the Union of India.
No, my lord, I am for the central GST.
And for the central GST, that following cases are pending before this court, which involve same issue as involved in, what is your case?
Mine is 1709 of 2024.
Once involved in WPC number
1709
of 2024, out of which 24 followed by the list. The present contempt application. The present contempt application arises out of the said WPC number
1709 of 2024.
1709 of 1709 of 2024, alleging disobedience of an interim order passed by this court. Stop. With the consent of the parties, let all the writ petitions, including WPC number 1709 of 2024, be listed on 4 weeks to be taken up at 2 p.m. Stop. The present content matter shall also be listed along with WPC number 1709 of 2024. Whether some certain matters are pending before Supreme Court.
No, that is
It is reserved.
No, that is relating to applicable tax. But here the question is challenging the rate of tax and retrospective effect.
Minority
There is no different issues now.
also goes into the root of the matter. Whether royalty is a tax, that India Cement is
That is pending.
reserved.
That is pending now.
So that has repercussion. We are one of our ground is whether royalty is a tax or not.
So what is the point involved before the Supreme Court?
Whether royalty is a tax or not. What is the character of royalty?
Prima facie royalty
It's a
cannot
9
be
basis
tax,
point.
but
No, Lord, that is pending, and I think Lord judgment is reserved because it has already been heard. Judgment earlier, your Lordship, Gulati is mentioning before Lordship on that case.
14th March it was reserved.
it may come after.
Yes, but here is something different. He is challenging the retrospective of the tax, 5% and 18%. That has been challenged.
But one of our ground is the royalty.
We will see every.
But he's accepted and paid the 5%.
If that goes, why not? This will not survive.
All right, we will see. We'll see. We want the main issue to be cited. Yes, you're right.
Below this. Would you point out good?
Item number 20. Item 20, my lord, the order has already been complied.
Compliant to jointly stated at the bar that this court's order violation of which has been raised in the present contempt applications been fully written proceeding stands stopped accordingly.
Item 21.
May I please your lordships? I want to visit my lord. My lord, your lordships on 22/6/June 23 directed the opposite party to comply the order, comply the order and dispose of the lease application within 2-3 months, my lord. But 3 months have been passed, but they have not yet taken any decision on my lease case, my lord. Your lordship passed the order 22 June 23. I have sent the communicated the order on 10/7/23, my lord. In the meantime, 3 months have already passed, my lord, but they have not decided taken any decision on my lease case, my lord.
Sakpati, why are you sitting in the dark? We can't see you.
My lord, I have one wish, my lord.
So you are alleging disobedience of this order?
My lord, disobedience of the order.
2023.
My lord, 22/6/23.
Yes.
Will obtain instruction because he says that either lease deed or sell deed. He doesn't have a right. He says that out of this land for industrial purpose, land should be allotted in his favor.
Without expressing any opinion. So you had to take a decision.
Like decision has been taken. Only Lordship may call it next week. I'll see that it's done. Also.
The prompt one. Just 2 months. we'll stop this course.
Who has to comply with the order?
Yes. OP number only contempt numbers. That is the secretary
Yes, ma'am.
department. Yes, one.
Item 22.
Made, please, Your Lordship. Your Lordship's order dated 22/1/2024. Page number 10, my lord, of the contempt petition. The direction was to comply within 3 months, my lord.
Where is the order?
So order is at page number 10, my lord. My lord, the petitioner is a D Pharma student, even though his mark sheet is available on the website of Odisha.
What is the order? Let us see.
My lord. Page number 10, my lord.
Who has to comply?
OP, the sole contender, my lord, the principal of the Gajapati College, Pharmacy College.
Okay.
I think it's a private college, must be not.
Private college, my lord, but the mark sheet is provided by Odisha Board of Pharmacy.
Then Mr. Mohanty will, Mr.
Who was opposite party number 5?
The principal of Gajapati College of Pharmacy.
Principal of Gajapati College of Pharmacy is a private institution.
My lord.
Which institution, where is the question of implementing any
My
direction?
lord, the mark sheet is published by the Odisha Board.
You did not seek any direction. Just see, come to the order 4 and 5.
My
We should initiate contempt proceeding against whom?
my lord, the mark sheet issuing authority is
Please come to, we are in contempt jurisdiction.
my lord.
We cannot punish someone who has not violated the order. Come to paragraph 4 and 5.
My
What is there?
the direction is to opposite part number 5.
Who is the opposite party number 5?
Principal of Gajapati College.
How can we punish the board official?
My lord, he's the issuing authority, my lord.
If the issuing authority, then the direction is against someone else.
To opposite part number 5, my lord. My lord, opposite part number 5 is the principal of that college, my lord.
And it is the details of in order of this board dated 2/1/2024. Maybe the blue is number 1/1/2024. So following is the order passed by the score violation of it. Paragraph 4 and 5. So opposite party applied the petition for the principal of Gajapati College of Pharmacy, which is admittedly privately managed college. So, the court order was passed on the very first day when it was taken in the absence of opposite party number 5. So top, in such circumstance, in the court's opinion, no case of deliberate disobedience or court's order is made out against the principal in the college of pharmacy was not a party in the relationship. Accordingly discussed.
My lord, I have communicated the order, my lord, as per court's direction.
Item 23.
My lord, I have communicated the order to the OP5, my lord.
23.
May I please, your lordship? May I please, your lordship? Item number 23. The order under Annexure 1 has been distributed by the Punjab National Bank, Dhenkanal branch. Your lordship, kindly see the operative portion of the order at page 17.
Yeah.
Order under Annexure 1, page 17. Your lordship, can see.
Yes.
Here the court has directed to final settlement of the loan amount. And after payment of the loan amount, the no objection certificate should have been issued by the present contender. But after settlement of payment of the amount, he has not issued the no objection certificate.
The court decided the amount which you should pay
Yes,
for
ma'am.
issuing no objection certificate.
Yes, ma'am. I have paid the amount which is under Annexure 2. And thereafter also make a representation
You
at
had come here challenging the order of the DRT,
DR 80.
DR 80.
When did you deposit the amount?
Your lordship, can see page 20 and 21. The copy of demand draft. and checks.
Yes. When did you deposit the amount?
Your lordship, can see page 20 for a moment. Page 20, 20.
You will not answer our query.
Date
Dates.
we are asking, you just mention the dates.
Sorry, madam.
Because you can't read the date from there.
10 to 24. 10th to 24. Another
Yes,
is
for bank. Who is from bank?
Lordship, either notices to go, or if the counsel who was appearing in that writ application, he may be directed to take instruction in the matter.
Did he appear?
yes.
Anjan Kumar
Anjan
Biswal is
Kumar
the counsel appearing then in the writ application. Page 11, his name is there not for the opposite party bank.
Do you think matter tomorrow? Oh. Right. Then asking for all. That's not yet, but- Done. Of your present application. On the against March 12. To have presented Punjab National Bank in Canal. In WPC number 33066 of 2012. So. The contain the application. The details of this court order dated 11/1/2024. Past 6 days has been alleged.
Public. One time. Okay.
But you serve it today.
Yes.
Item number 24.
The order dated, my lord, 8 April 2021, page 15. Your lordship has directed that division direct to pass the penalty and direct to refund within a period of 2 months. State preferred SLP. That is also, my lord, dismissed. I have annexed the order copy of SLP.
Yes, now, because lordships were pleased to dispose of the earlier contempt application, stating that liberty was granted to move after the SLP. Now the SLP has been dismissed. We have to comply. Lordship grant me 2 weeks time. In the meantime, for the first time, it has been listed 2 weeks time.
For obtaining instruction as to whether this court's order violation has been compliant with all.
Item number 25.
25 also same, my lord. Same issue. Same.
26.
26, my lord, is different. Your lordship. Lordship has here I have came before lordship to allow some time to complete the balance work. I finally allow some time. It is a government contract bridge work. I could not complete it. It was rescinded. I came before lordship, and during hearing I filed a affidavit undertaking that I will complete within a period of 6 months and will not claim escalation to minimize the problem. Your lordship, considering that my affidavit dispose of the petition may be permitted to execute the work within 6 months, failing which the action will be taken as per the tender conditions. This order was communicated. I started the work. The opposite party number 5, executive engineer, he say you can't start work unless the approval of the higher authority. Once the court permitted, my lord, they have my lord, the E6. That is, my lord, that's why I'm here in contempt.
I'll file the instruction because, of course, your lordship says this also directed that in view of the affidavit filed by him that he will execute the work. Also allowed him to execute the work. So now I will to.
No, they were noticed.
Yes, yes, the notice and the annex 6, my lord, the opposite party number 6 reply that in spite of court order, I have to take permission of the higher authority.
Writ petition.
Yes, notice, my lord, page, yes. Earlier, your lordship, that page 15. Page 15, your lordship, the getting notice, your lordships.
This is item number?
This is, my lord, 26, your lordship.
26.
Your lordship, come to note regarding page 17, your lordship's query, page 17, annex 2.
This is the order.
This is the regarding query, my lord, whether they have notice or not, your lordship.
The basis of your affidavit, it was disposed.
Yes, lords. This is a half construction base, my lord, I complete, my lord. This is the difficulty, my lord. And the monsoon is due, my lord. So.
No, Mr. Sorry, that is not the order. Where is the order?
Paragraph 3. In view of the affidavit filed by the petitioner, the writ petition can dispose in terms of the averments made in the said affidavit.
Page 22, lords.
12/1/2025, page 26.
Page 22, minutes.
I got it.
Page 24, your lords, can have 25, your lords, 28, your lords, the communication of the department. Is to wait from the higher authority. That's page 28. 28, your lords. And extra 6 minutes. Lord, with reference to subjected cited above letter, I am reading the placing fast paragraph. It is to intimate that in obedience of order number 3 dated 12 January 2024 of Honorable High Court of Odisha against the WPC number 37679 of 2023, the matter has already been communicated to the Chief Engineer World Bank project by this office letter number 18/1/2024 so as to obtain permission from the competent authority to resumption of the work. Any specific direction in this regard yet to receive this office. But this is on 20th April 2024. Thereafter, in the meantime, we have intimated by a letter number so dated 18th April 2024, the staging work span 2 has been completed. Since the work has been taken up without any financial approval, without any regular supervision, the permission could not be given proceeding ahead in enforcement of the SAP.
That 18-4 letter you have given separately to all or just one letter mentioning the names?
Pardon,
Is this your submission? That because of that order, so when the order was passed, after an hour or so, you could have started. Is this your submission?
My humble submission, my lord. Your lordships, I know, my lord, my jurisdiction in contempt proceeding, my lords. But I have humble submit, my lord, when the matter.
Your jurisdiction, what is jurisdiction, and they have also to ensure the executive, they have also some duty to ensure that if a bridge is constructed, it is constructed in accordance with design. See, all the.
Yes, lordship, the 6 month, your lordships.
What is the order? You have intimated this office while you have later dated 18/4/2024. What is the date of the order?
Oh. What is date? Your lordship's order dated is. Yes, lords. That is 12 January 2024.
12-1.
12-1. This court, your lordships, the 29.
Those outside is. Outside.
Extra 4.
The order was passed on 12/1/2024.
Yes, my lord.
What did you do thereafter?
It's an extra 4, this is the my lord, communication order.
What did you do?
My lord, this is 18th April 2024.
18th April 2024.
Well, it's
Gave by post or personally?
So order was passed on 12/1/2024. On the basis of your undertaking that you will complete the work.
Yes.
You opposed the authority more than 3 months thereafter. So it was impossible for you to complete the work. And then they take note of this fact that you have intimated this office by your letter dated 18/4/2024 that staging work of span has been completed. Since the staging work has been taken up without any official approval from this office and without regular supervision, this is the regular supervision is a construction work.
yes, regular supervision required.
Without regular supervision, so what the order, if you obtain, suppose you could have approached the authorities after 5 months. There is your intention.
Yes, your lordship, your lordship, 1 minute, my lord. Lordship, can you? But your lordship is directed to for 6 months from the date of order, my lord. Yes, there is a part of the petitioner, your lordship, they failed to do communication of the order, my lord. This is from the records, my lord. But in fact, your lordship has, there is a order that 6 months will be however, it is the order is paragraph page 23, my lord. Your lordship has directed if petitioner does not carry out the statement of paragraph 3 of the statement, you will do in accordance with law. But here they have denied because of not that they have not approached before this time. They rejected that we are need for more instruction for the higher authority.
Because meanwhile, you had done something which was not done in supervision of the official. That was required. And then your
Your lordship is good. One more submission, Your Lordship. In the context of my affidavit, my lord, is the contempt jurisdiction, Your Lordship, but the object that to ensure the project to be completed, not that, my lord, will go into. So, my lord, this can be minimized, my lord. Your lordships can consider this because they say that I am still without any escalation. I have sued our affidavit. I undertake still complete the work.
No, escalation is different thing. That thing is a public work. It's a bridge.
Is a breeze, half constructed. Bridge.
Without supervision, you are constructing.
No, I am
what
not.
happened? No,
Some part is
look
they
at
have
your
written.
letter. Look at
Yes,
your
sir,
letter.
they have written some part of.
No,
So I stopped that.
You yourself.
Not that for that reason I come to comply the order. I come. I stop that. Not that if I complete, I stop that order.
We think the staging work of the span seems to be approved.
So this is difficult. This is not half position.
Order. Statement that in the additional affidavit filed by the petitioner or that is photo the data application. In following term, paragraph 3. The undertaking which was given paragraph 3 of the additional affidavit says counsel for the petitioner has drawn our attention that attention to a communication created
That letter. 24, 2024, page 28, annexure 6. Right.
This to the wherein it has been mentioned that the matter has been communicated to matter has been communicated to the city user but on 1/2024 to obtain permission from the competent authority for the mention of next. The council has submitted that once the order was passed by this court, the authority should not have waited for obtaining permission from the competent authority for the function of the work. And it is on the significant part of the state communication, which is 24, 2024.
Yes, yes.
We do not does not find that the in case of the deliberate case of court order is without so considering the nature of the work which was to be executed, the officials, concerned officials rightly pointed out in their application about certain work executed by the petitioner in the absence of without any regular supervision. So, we are not like feed in the present matter. So, petition and
Item number 27.
May I please your lordships? May I please your lordship? My lord, I humbly invite attention of your lordship with respect to the order passed by this honorable court
Same as 24,
at
25.
page 16. At page 16.
Similar to 24, 25?
Yeah.
This is similar to 24, 25?
No.
Radhesham Agarwal.
Radhesham Agrawal, the lordship were pleased to take a decision, refund the amount in, I will obtain instruction, the lordship will grant me 2 weeks time only, my lord, sir.
2 weeks. On 2 weeks to enable learned AGA to seek instructions as regards full compliance of this court's order, violation of which has been alleged in the present contempt application.
Item 28.
May I please your lordship, my lord? Non-compliance of the order dated 4/4/2023 passed by the honorable court in WPC number 7036 of 2010, my lord. Annexure 1 in the order, my lord. Kindly say, running page.
Just
Non-compliance of the order dated 4/4/2023 passed by the
which order? Which order has been
order,
disturbed?
my lord, Annexure 1, running page 11, page 30.
When was that order passed?
Passed, my lord, order dated 4/4/2023.
4/4/2023.
Terms of.
Honorable court, my lord, running page 13.
Annexure 1.
Yes, my lord. Honorable court directed to the opposite party number 4 and 5.
48.
Opposite party number 4. Yes, sir.
Annexure 1 at page
Page 13, my lord.
13.
13, paragraph 1, last line of the order, my lord.
Starts at page 13, yes.
Opposite party number 4 and 5 be commanded to release the arrear salary remuneration of the petition with effect from May 2009 till date, my lord. But the opposite party number 4 and 5 not comply this order till today. Present petition work is the form driver, my lord.
What is it?
My lord.
And what is there in this judgment? WPC 6871.
6871, the judgment stated, judgment WPC 6871 2012. Similar case or to the case and
Yes.
It's Sarpanch mayor, so we don't have anything. So container is the Sarpanch of the Gram Panchayat.
Forms are there or not, God knows.
No, but what is there in the order? WPC 6871.
6871 not filed with the judgment, past judgment, as per the judgment.
And who will comply with the order?
6871 judgment.
Not noticed.
There is no OP6 in the repetition.
Yeah, that is why order was carried out, corrected OP5. That is at page 14. Order has been
Wrongly
corrected
I am
at page 14. In IA,
page 17.
All right. Opposite party number 5, whether opposite party number 5 was noticed when the order was passed.
Opposite party, my lord, modification.
See, you, according to you, opposite party number 5 has committed contempt.
My lord.
Because he has not obeyed an order passed by this court.
My lord.
Was he a party?
Is party, my lord?
Was he noticed?
Notice.
Noticed?
notice Sarpanch.
So when was the notice issued? See, that is the first order
My lord.
passed in the writ petition.
It's go to the notice date.
It will open for the petitioner to supply the certificate copy of notice for the further disposal.
First the disposal notice.
First day disposal, no contempt. The 7th. Your Honor, 14. Put up this matter on Monday along with the records of WPC number 7036 of 2010. Let us see whether Sarpanch was noticed or not.
Item 29.
Yes, item number 29, sir. I pray Lordship, because it has been listed for the first time, second count, Lordship, 2 weeks time I have talked to the officer, I will try to do the needful rules.
So your so many orders have been complied with.
Yesterday, my friend was not there, one of his cases order has been, and this is the same,
Yesterday, the order was complied.
Requested on behalf of Captain Nurse. To discuss matter on these matters on 2 weeks, so as to obtain instructions as regards compliance of this court order, orders violation of which have been alleged, violations of which have been alleged in the rigid batch of cases. सबको अलग order कर देंगे separate order, सबका separate order. Same order. Right. Same order, same order. I have done it.
Item number 30.
Non-compliance of the order dated 8 February 2024, my lord. Conditional report, my lord. That is under Annexure 1. And duly communicated to the opposite party number 2, that is Project Director Jharsuguda, on 15 February, along with the annexure. In that annexure, my lord, the petitioner is identically situated to the situation of the one Prasant Kumar Tete. That is also submitted before the authority. But till that,
there is nothing in the order.
At least, my lord, there are documents, because they are the land user, my lord. Their documents are also not verified by the authority. And whether they are fitted to the Sukhavasi scheme, that is also not verified. No any letter also intimated.
Yes, why this order is not.
No, sir. I will obtain instruction, but OP number 2, if OP number 2 is the
Project Director,
collector, because there is some
So you
confusion.
filed
Yes.
contempt application on 8/5. When did you file the contempt application?
Content, my lord.
No,
16/5, my lord. 16/5.
16/5.
Yes,
So
16/5.
slightly belated, no? 8/2/2004, the order was passed. Dispose it off.
I got it, but there was some confusion because he says that block education officer post Sundargarh is the contemnor. That is why I could not get instruction. There was some confusion.
Just a minute. Who is opposite party number 2?
Read petition, my lord.
Opposite party number 2. Who was the opposite party number 2?
Project Director come Collector Jharsuguda, my lord. In the read petition. That is opposite party number 2. Project Director other than from Collector Jharsuguda.
Collector Jharsuguda?
My lord.
Opposite party number 2?
Yes, in the read petition.
And your representation was pending before opposite party number 2?
Yes, my lord.
No, what I am saying.
Annexure 3, your lordship can have a glance.
Just a minute, just a minute. Yes.
I was confused because lordship come to page, that cause title page, first page below. Yes, so block education officer, he said the representation was before the collector. So I could not contact anybody, how that. No, that is the, I could not also get instruction from anybody.
Another application has been pending before the block education officer for service, my lord. No, but the opposite party 2 is the authority, my lord, to decide the case. I have to file a corrected petition. Permitted to withdraw my to be file a better petition.
And counsel for the petitioner submits that. The current counsel for the petitioner seeks to withdraw the present contempt application for the present contempt application. The contempt application and dismiss as withdrawn. Yes.
Item 31.
May I please, my lords.
Encroachment.
Well, let's I pray 3 weeks time for amending the petition because the regent order has not been passed and that has been communicated with the present petitioner as per the direction of this honorable court. My lords.
Petition was there.
The order dated 27/3/2023 at page 11.
No, where is the order?
That is the order passed in the WPC number 8314 of 2023. Order dated 27/3/2023. The petitioner's representation under Annexure 3 shall be examined by the Tahsildar at court opposite party number 2.
No, where is that order?
My lords. The regent order shall be passed thereon not later than 1st June 2023. The said order be communicated to the parties within a week thereafter. The court clarifies that is so and so. And after notice to the petitioner, the encroachers, the above annexure 3 shall be and given an opportunity of being heard. That it has also to be heard. The petitioner neither has been noticed nor he has been given an opportunity of being heard, nor any regent order has been passed. Because there is encroachment of 5 acres and for 91 decibels of grazing ground of the cattle that has been occupied and the construction has been raised, it has been completed with the full knowledge of the Tahsildar, so also the revenue inspector.
Where is your annexure 3?
My lords. At page,
Yes,
running page 18, my lords.
So before that writ petition, there was another writ petition.
No. One writ petition, 2 annexures. The earlier writ petition.
And the reason order has not been passed.
No, my lords.
Where is that order?
The regent order has not been passed because that has not been communicated to the present petitioner. So I pray time adjournment for amending the contempt petition.
Why?
That has not been communicated. It has not been passed. The petitioner has not been heard.
So lordship come to page 17 in the certificate given to the writ application which is not sought to be not so challenged in the contempt. There is a writ application WPC number 36980/2022 PI.
That was withdrawn. Withdrawn.
That is what I have noticed.
That was withdrawn.
That was disposed of on 10/1/2023.
Usually then orders were passed that it is not in proper format, so they will file, I mean, the order is not here, but they just give one line stating it was earlier, where nobody knows what the order is.
3 weeks time.
There are no opposite parties. General public is occupying the Gochar land.
Tell us whether the reason order has been passed or not.
No.
With this case on. So it's enable and AGA to seek instructions as to whether this court's order dated so and so describes the evidence has been complied with or not. Has he understood? Has he understood? They understood. Huh? Order district.
Item number 32.
May I please, Your Lordship? Your Lordship, this contempt petition has been filed challenging the non-compliance of the order dated 21, alleging the non-compliance of the order dated 21/8/2023 passed by this honorable court, wherein a direction was given to the contemner to consider the representation filed by the petitioner and pass an appropriate order in accordance with law. Your Lordship, the grievance of the petitioner was that the petitioner was claiming for compensation relating to the land acquisition case that was pending before the contemner, Your Lordship. Thereafter, Your Lordship, instead of passing a final decision, Your Lordship, the contemner has made certain observations regarding not being able to find the case records, and the contemner has simply shifted the charge to some other officer, the requisition officer, instead of taking a final decision. As a result, Your Lordship, the petitioner is forced to move from pillar to post, and since there is no final order, Your Lordship, neither the petitioner can challenge the same, nor the petitioner has got the fruit of the order.
But they attempted to comply with the order.
But Your Lordship, contemner is the appropriate authority to pay the compensation, Your Lordship. By shifting the charge to the requisition officer, Your Lordship, he is not the authority who is to give compensation to the petitioner.
So that may be illegal. But the decision has been taken. You can challenge it.
But Your Lordship, they have not.
See, one order was passed. One order was passed by this court.
Yes, Your Lordship.
The contemners were required to carry out that order. They carried out that order wrongly. This is your submission.
Your Lordship, it is the spirit of the order has not been complied, Your Lordship. The
Like?
spirit was to take a final decision, Your Lordship.
Yes.
And the appropriate authority is the contemner.
You are saying appropriate authority is the contemner, but they are saying something else.
No, but the opposite party would have been the appropriate authority had there been a notification land acquisition. There is no notification of acquisition. That is why he requested to make a requisition for this land acquisition. There is no proceeding. Where is the question of compensation?
For direct purchase.
No, whatever the mode, my lord. So that is why he has stated that the superintendent engineer who has utilized their land, he should give a requisition for either acquisition or direct purchase, my lord. So he has complied the order on his part, saying that, my lord.
Your Lordship, there was no notification for acquisition is not true, Your Lordship, and that is also not the observation in the order passed.
No, in the order, there is no observation.
Yes, Your Lordship.
No, last two lines, Your Lordship, may kindly read me on page 16.
So your representation was to be considered. That's all. They have considered. They have passed an order.
Your Lordship, my grievance was for the payment of the compensation.
That was not the direction.
Your Lordship, had they rejected my claim, Your Lordship, I would have challenged the same.
They cannot. They were required to consider your representation and pass an order. They have considered your representation. And who was required to consider? OP number 4.
Yes, Your Lordship.
OP number 4 has passed the order.
But he has not passed any order, Your Lordship. He simply shifted the charge to some other officer.
Get your matter adjudicated upon.
Isn't that an order?
But Your Lordship, it's not an appropriate order in accordance with law.
Not you have to file another petition. But he has complied with the direction.
But not regarding my right, Your Lordship.
Right, you cannot.
My grievance was regarding the payment of compensation.
Cannot.
Had that been considered in true spirit, Your Lordship, then at least a decision should have been.
Spirit, very difficult. See, if and pass appropriate order.
Yes, Your Lordship.
And he passed an inappropriate order. And therefore he should be punished. It's very difficult.
Your Lordship, he has not taken any decision. That is my
This is
submission.
that is you can blame his mind. You can blame his competence. You can blame his inefficiency. But you cannot blame his intentions.
But whenever the order was to consider my representation, it was not to pass
Let
some
us-
observation,
let
Your
us
Lordship.
don't-
You can challenge that order.
The petitioner in the present contempt application alleges disobedience of an order dated 21/8/2023, passed by a coordinate bench of this court in WPC number 26631 of 2023. So, following is the operative part of the order, paragraph 5. Stop. From the records, it appears that the land acquisition officer bracketed civil collectorate Jajpur bracketed OP number 4 in the writ petition has taken a decision and disposed of the petitioner's representation with an observation that superintending engineer, Jajpur irrigation division can be requested to submit proposal for acquisition of land in question to direct purchase for early disposal of the same. So, the petitioner's representation has thus been disposed of, has been considered by the OP number 4. So, if the in our considered view, no deliberate disobedience of this court's order by the said contender is made out by land acquisition officer bracketed civil collectorate Jajpur is made out. So, the contempt proceeding is accordingly dropped. So, this will not, the dismissal of the present contempt application will not come in way of the petitioner in pursuing the matter for payment of compensation before appropriate authority in accordance with it.
Obliged, Your Lordship.
Your Lordship,
I will obtain instruction. Your Lordship's order. Lordship directed to examine the case notes in accordance with that judgment and take a decision. That I will examine. Lordship, I will file it.
How much time?
Lordship may grant me 4 weeks time later because February your Lordship were pleased to pass the order.
As requested on behalf of the contenders by Mr. Also AGA. Request based on 4 weeks. So as to enable him to obtain instructions about the impact of this court's order, violation of which has been alleged in the present contempt application.
Obliged.
34.
Non-compliance of my lord's order dated 21/9/2023. My lord may kindly turn to page 14, paragraph 8.
Yes.
I have communicated them under annexure 2 at page 16. By hand as well as by post. Till date, my lord, my instruction is that I have not considered my representation nor communicated me any order that they have complied your lordship's order. Either way, they have not communicated.
Yeah, the order was passed on a review.
Review.
It was reversed.
Reversed.
The claim was for compensation regarding that construction area in the Puri, in and around temple, where they have given to some other persons and not provided to me. Mane us, madam.
The compensation at a higher rate or something.
Higher rate.
Whatever, you have to take a decision.
Only one thing, your lordship, paragraph 8 of the order, lordship directed that the collector and district magistrate Puri to consider the repentance of the petitioner, which the petitioner may file. But next page 16, there is no proof that repentation has been filed. Here, yes, the receipt shows that only a copy of the order.
Along with the copy of the order, we have filed a representation.
So, that is also not annexed. So I'll find out whether he has filed or not. So lordship, can be some time. I'll find out whether such repentation has been filed in pursuance of lordship's order or not.
Yes.
No, please come to page 16.
16, yes, lordship. Received the copy of the order dated 20/9/23 passed by the Honorable Justice A.K. Mahapatra, High Court of Orissa in revocation of such and others addressed to the collector Puri. Repentation, there is no whisper about the repentation, my lords.
This is the receipt which they have
I
given.
don't dispute that. Receipt, it has been given by the receiving officer.
No, but where is your representation?
My lord, we have filed a representation.
Where is that representation?
My lord, that
And order passed by Justice
my lord,
A.K. Mahapatra.
I have not annexed, but it's.
Then we cannot proceed.
They've written a yes sign, well, that is all.
But it was put to their knowledge.
Which order did you communicate, Mr.
See,
Bose?
you might have sent the order and not your representation.
No, my lord, we have sent the order as well as the representation because that is I have taken instruction. Man.
That instruction will not do. The petitioner is alleging disobedience of this court's order dated 21/9/2023, passed in RV WPET number 102 of 2022, paragraph 8 of which reads as under. Next, on careful perusal of the contempt petition and the annexures appended thereto, we do not find any conclusive material to infer that the petitioner had in fact filed any representation in the light of this court's observation in paragraph 8 as quoted above. Stop.
But your lordship may see, I have got the copy of the same also, subject to if your lordship may kindly have it.
Mr. Bose, paragraph 3 you have not stated.
But it is there, man. And yes, your lordship, please.
In such view of the matter, we are not inclined to proceed any further in the present contempt matter. Stop. The contempt proceeding stands stopped. Yes.
Your lordship may kindly permit me one. Your lordship may allow me that I'll file a fresh
contempt, second contempt.
Second contempt, enclosing all the documents. Because my door will be closed, my lord. Now I cannot invoke your lordship's jurisdiction in any form.
You lost that, right? You were given this liberty to make a representation.
My lord, I have made in fact, it is not annexed, but I have got the document that we have filed by post.
Mr. Counsel, it is specifically mentioned in this receipt, received the copy of the order passed by so and so. So they did not receive any this thing, your representation.
If the authorities do not write that, but if I get a copy, I can produce by way of an affidavit that I have produced.
Sorry.
Then your lordship may consider the same also.
Sorry.
Or else your lordship may grant me some liberty to.
It will be, the petitioner shall be at liberty to pursue his remedy before the competent authority.
Lady.
The petitioner shall be at liberty to
For orders item 35.
when this matter was listed yesterday, there is a delay of more than 410 days, my lord. And the only issue involved in this case, my lord, the petitioner was brought over to the Varchas establishment with effect from 3/4/2010. 3/4/2010, the order was passed, but it was given the retrospective effect with effect from 1/3/2009. So they are claiming, the respondent claiming the arrear dues with effect from 1/3/2009 instead of from the date he actually joined the post. That is the only issue. But similar matter, your lordship have already dismissed. I have the ground.
Where's the order?
That was order.
Delay and don't appeal business.
Well, in similar cases, your lordship has dismissed that
an
copy.
order. You don't
That
have any-
copy.
Say order copy done.
Number कौन है?
I tell them point. In fact, yesterday your lordship was asking that question whether there was lapses on the part of the respondents or on the part of the government. If your lordship will find from that order was passed in October, that they were brought over to Varchas establishment from 1/3/2009. So there was no lapses on the part of the respondents. So for that reason, your lordship in the similar case has already dismissed.
So where is that? Do you have a copy of that order?
My lord, if your lordship may adjourn to next week, I will produce that order.
Number भी नहीं.
Number. I will give your lordship may adjourn produce.
As a question. Okay, appeal business matter also 1 week.
Item 36.
Item 36, this is the Sartapada matter, the pension regarding that block grant employees. There is a limitation, your lordship may issue notice on the question of limitation.
Yesterday there were number.
Yes, similar matters, your lordship.
Yes.
I could have given this copy because your lordship has already disposed of some matters reminding, but since the limitation is there, your lordship may issue notice.
Item 37.
37 also Sartapada. 37, 38. Three matters are Sartapada. All these cases are limitation.
7, 38, 36, 37, 38.
Mile.
Item 39. Here there is a delay of 30 days. The Honorable Single Judge disposed of the writ application by virtue of the impugned order, referring to the judgment passed by the Honorable Apex Court in case of Malayananda Sethi. The Honorable Single Judge set aside the order of rejection. The claim of the petitioner, the rejection order passed by the authorities, rejecting the claim of the petitioner on the ground that he was found unsuitable for appointment under the rehabilitation assistance scheme in terms of the new rule. Here, my lord, the death of the father of the petitioner occurred in 2017.
So why are you, there is no, in fact, very innocuous order. The petitioner took a plea that his case is squarely covered by Malayananda Sethi versus State of Odisha. Whether this is correct or not?
That is not correct, my lord.
That is not correct. Now come to paragraph 4.
My lord.
Paragraph 3 and paragraph 4. All right. Even then, let us examine how is this case different from Malayananda Sethi? What was the issue involved?
But so far as the case of Malayananda Sethi is concerned, there the application for appointment under the rehabilitation scheme was kept pending for 10 years. And considering that peculiar facts and circumstances of the case, the Honorable Apex Court allowed the writ application directing the authorities that his case should have been considered in terms of the old rule, that is Odisha Rehabilitation Assistance Rule 1990, and not under the new rules. That was the issue and the direction. But here is a case where the father of the petitioner died in 2017, and immediately he made an application, followed by the affidavit by the spouse as well as the elder brother. Then subsequently that application was placed before the evaluation committee prior to commencement of the new rule, and that was considered, and finally the order was passed by the evaluation committee after commencement of the new rule, but referring to the not new rule, my lord, old rules. They found him ineligible, and at the first stage,
So then why did you take? All right, you can seek review. This is a good ground. What you are submitting is a good ground for review. If your review application is rejected, you can say that it was either out of some misconception or something, or what the point which you are saying is maybe a very good ground for review, but not.
my lord, we could have brought these facts to the notice of the Honorable Single Judge.
That is what we are saying.
Had we be given the opportunity to file the counter affidavit.
All right, so then now you can say, appeal will not interfere. Then counsel appearing on behalf of the appellant seeks permission to withdraw this appeal with the liberty to seek review of the when counsel for the appellant has submitted that it appears that out of inadvertence, a submission inadvertence or some misconception of law, and counsel representing the state could not dispute before the learned single judge that the respondent's case was not covered by Malayanand Sethi versus State of Odisha. Malayanand Sethi versus State of Odisha. Civil Appeal number 4103 of 2022, disposed of on 25/2020. Stop. Next, the said submission can be when counsel for the appellant states seeks permission to withdraw this appeal, comma, after some argument, comma, with a liberty to seek a review of the said order on the aforesaid ground. Stop. Accordingly, this appeal is dismissed as withdrawn with a liberty to the petitioner to seek review of the said order. All right.
I'll just subject to my lord's acceptance.
Intra-court appeal has been filed on behalf of questioning, challenging an order.
Only to put the correct facts before my lord. My lord, the application of the petitioner was considered and rejected under the old rule. Thereafter, the petitioner was asked to again resubmit another application in terms of the new rule. And again, on consideration of the new rule, the application was again rejected. So that is how he approached the Honorable Court. And the Honorable Court, referring to the later part of the consideration, that is in terms of the new rule, passed the order that is in view of the Malayananda Sethi, his application should have been considered.
We have not stated anything. It's just, this is your submission that it is not covered by Malayananda Sethi. You can take that.
Item number 40.
40. Here there is a delay of 205 days, my lord. Here the issue is the petitioner. आपण आपल्या question
I don't know how many, my lord. I am for caveator. Let us serve. I am for the caveator, my lord. Let us serve a copy.
You are?
I am for the caveator. I am the caveat petition. I have filed caveat petition. Let us serve a copy, my lord.
I'll serve it.
May not be required.
My lord. As your lordship.
Yes, what is the order?
Here, my lord, the impugned order, that is at annexure 1. Here the issue is, your lordship may kindly have a glance to the resolution, basing on which the recruitment process was carried out. That is at page 42.
No, what is there in the order? Or how the order is not legally sustainable?
The order is wrong to the extent, my lord, the findings of the Honorable Single Judge at para 7 of the order. I'm placing just last 4 lines of the para 7. Since the advertisement under annexure 2 is not very specific, asking the candidates to file an affidavit that he has not made any application in respect of any education district coming under any other revenue district, the stand taken by the opposite parties while disengaging the petitioner is not sustainable in the IF law. Now, if your lordship will look at the advertisement and the government resolution, basing on which the recruitment drive was carried out for engagement of Shiksha Sahayak, your lordship may kindly have a glance to page 40 of the writ appeal. Page 40 is the government.
But there was an interim order.
My lord, pursuant to the interim order passed by the Honorable Single Judge, the petitioner was allowed to continue in service. But the order, the findings of the Honorable Court, Honorable Single Judge in para 7 runs contrary to the government resolution, which was the basis for the recruitment, my lord. That resolution of the government, that is at page 40.
So resolution of the government must have required that application can be filed only for one district.
One district, supported by an affidavit that
he had not applied for
any other district. Here, basing on that affidavit, vis-a-vis his performance, he was allowed to. He was issued with an order of appointment. Later, it was found that he was an applicant for another district. So the affidavit filed before the authorities, that proves to be a false affidavit. So basing on that, a show cause was issued. Then he submitted his reply, considering all the aspects.
What was the reply?
His reply was, he accepted that.
Then?
In his reply, he accepted that. Your lordship may kindly have a glance to page 45. The government resolution, I just go serially, my lord. Page 42, your lordship may kindly see. The condition stipulated in the resolution, that is 5.1. Page 42. 5.1 A.
Mode of application.
Mode of application, madam. The candidate shall have to furnish an affidavit with his or her application to the effect that he /C has not made application for engagement of Shiksha Sahayak in any education district other than the education district until applied for. If on verification, it is found that the candidate has applied in more than one education district.
Yes, he should.
He's appear.
Yes, he is a parent.
Del-
It's on
delay-
office.
delay.
For accept notice. Delay भी happened on it?
Delay means I don't know what is the date.
205 days.
Minimum,
205. All right, accept notice.
delay, my lord, long delay. More than 6 months delay.
205 days is.
Hello?
205
Yes,
days.
ma'am, yes.
It's very normal.
My lord, what is it? I can't say. But fact remains for 13 I have continued in service. Fact remains, on 13 I have continued for 10 years part in the meantime. And the resolution that submit that relates to only one district. I applied for Dhenkanal, Ajula, Jajpur, not in Dhenkanal other district.
No.
Rule says within one district, within a revenue district, 3 education districts there. I applied only for one district, one revenue district of Dhenkanal district.
Revenue district or education district?
In every revenue district, that three education district. I applied only for one. They said, why you applied for in the revenue? Jajpur district, that is separate advertisement, not this advertisement.
Education district unit.
Unit.
That
As a district for the revenue district, the advertisement issued by the collector Dhenkanal. The second advertisement by another district, collector Jajpur. No link at all. Another district advertisement issued by collector Jajpur, not by same authority, my lord. Separate authority, separate advertisement. That is not decided. This one decided.
Same education district, you can make application.
Within Dhenkanal.
You should not have made.
Yes, ma'am.
Other you can.
Yes, madam. That's why they decided this one single judge that because separate advertisement, say another district, no link to Dhenkanal district, so his application justified. That not allowed and 10 years part in the meantime. All my friends are retired, have been regularized. I am only one person suffering from it, and I will retire only with 2 to 3 years. I will superintendent service.
All it will see every aspect. But what is this? And you can, there are different advertisements, you can apply.
Yes.
One district, we cannot apply from other district.
Madam.
What is it?
That is that advertisement itself also contrary to my judgment that the person can restricted to only apply to one district only. That is in 2017 Supreme Court, our own High Court judgment. You can restrict the application forms.
But you did not challenge that.
I applied for Dhenkanal district. The advertisement issued by the collector, not by the government. Now, kindly the distinction is that advertisement for Shiksha issued by collector, the collector of the revenue district. That I applied for the revenue district for Dhenkanal.
Based
Only
on
for
the resolution of the government,
government humanities.
which is at annexure.
Yes, government resolution only one revenue, only one education district. Never said only.
So there were 2 separate advertisements.
Yes, madam. That are not single judge decided. That may enter case, madam.
It appears to be correct. All right, you will see. Except notice. We shall condone the delay.
That is up to madam. I never stand on.
Considering the facts and circumstances and the higher number and the amendments made in the application and the submissions advanced on behalf of the parties, the delay in filing the appeal, delay of 25 days and present the appeal is condoned. Of this matter for admission when? When do you want?
Let us serve a copy first. I have not issued any copy.
He will give you today. When do you want?
2 weeks, madam. Immediate after 2 weeks, madam.
This is 2 weeks.
Madam,
First 5 cases.
Ajay, madam. Yes, sir, madam.
I have filed an interlocutory application seeking stay of the order.
No. Stay, there is no question of stay.
Obliged. But item 46 also same. Item 46 also same.
46, someone, who is appearing?
There is a delay of 113 days. Same issue, madam. Same day.
Item 41.
May I please, madam? I'm extremely apologetic because I filed the requisites a little late for which the notice.
41.
Yes, you filed?
The requisites for notice were delayed in a delayed manner. I apologize for that. That is in the notice couldn't go.
Notice couldn't go.
Madam.
No, when it was taken up on 9/4, there was no representation. What is the office note? When did you file your requisites?
My lord, 11th.
24/4. Thereafter was supposed to file, but he has not filed.
Now you have filed.
My lord.
11/6.
It is stated by learned counsel for the commissioner, appellate, that the requisites for notice pursuant to the order dated 24/4/2024 have been filed, but belatedly. So, next. In the facts and circumstances, we direct that the requisites submitted for issuance of notice be utilized for issuance of notice to opposite party to the respondents.
Obliged, my lord.
Is this matter on August?
Yes, August first week, second week.
Second week of August.
So July plus 2 weeks more.
Obliged.
Item 42. 42, there is a delay of more than 1 year. A delay of 1 year. But here, the issue is the petitioner was brought over to the Varchas establishment in 2011. And thereafter, he retired from service.
Where is the order?
Lordship's order, that is at page 15, Annexure 1. That is, the matter has been disposed of in terms of the judgment Narsu Pradha. Similar matters, your Lordship have issued notice. Similar matter, your Lordship have issued notice. Narsu Pradhan.
Then WA 432 of 2022, similar matter, the Lordship has issued notice and it has been fixed this month for hearing.
No, it is not a cruelty letter.
WA 432 of 2022.
Item 43.
And still, there is limitation of 162 days. See, there regarding that Sartap Porda case. Pension, block grant, notice on limitation.
Item 44.
44 also same. There is also limitation.
69 days.
କାଲି ଗୋଟେ ଥିଲା WA 430 no sorry WA 887 of 2023.
Yes,
That was
ma'am.
there yesterday, right?
Yes, yes.
So your item 36, 30,
That is 48.
36, 37, 38 of the day, as well as 43.
44.
Not 43,
Yes, 43 and 44.
44. Tagged with WA 887 of 2023.
Well,
Who date for right?
23rd July. Item 45.
in 45, there is a delay of 62 days delay, madam. 62 days delay. This is the matter regarding that promotion during pendency of departmental proceeding and vigilance case. Your Lordship has decided the issue, but this limitation is there. Your Lordship may issue
notice.
Item 46.
Yeah, Mr. Can we know Why in each and every appeal, this application is being filed for condonation, for dispensing with the filing of certified copy?
Well, at that, your lordship has passed that order before vacation, we will get the certified copy within 2-3 days. But prior to that, we have applied, our office has applied and
Please use that.
not
Please do
necessarily,
that
as
now.
per the High Court rules, we have to submit the certified copy. See, as certified copy was not filed at the time of filing of the writ appeal.
No, see, you are filing the writ appeal after 365
Yes.
days.
Yes, madam.
And you don't
Yes, ma'am.
have the certified copy.
I understand, madam. In fact, what happens, madam, that is the fact. Certified copy has been applied, but the department is coming with that Xerox copy. So there is a communication gap between the department and our office. So there is, at the time of getting that certified copy, our office is applying and they have not applied. Someone has applied, there is a communication gap. So we'll regularize that. That I will
Apply for 2 certified copies. Give one to the department, keep one with you.
Yes, madam.
And you should use this online.
Now that will, if, after my lord's order, before that vacation, your lordship has passed that order, we'll get that certificate. That this will be regularized.
I am monitoring this.
Yes, madam.
Think of monitoring the system of issuance of certified copy. Just think of the
This will be
predicament
regular,
of a
madam.
Chief Justice. That he is
No, madam. Some days your lordship will get that there is no eye for dispensing with. But these are filed before vacation, madam.
No, even if you
And
file.
if you have any difficulty, if you have anyone has any difficulty in getting certified copies,
yes, madam. That
they can come in the Chief Justice's court. I invite them.
The reason of high time, certified copies which are incorporated in the High Court rules should be removed. Now everything is online. Why not online?
No, certified copy
Available online.
has its own importance because when it is issued, someone certifies that this is the order, copy of the order which was passed. So that is there. But you get your certified copies online within 2 days. So with digital signature. So that practice you should adopt.
Yes, madam.
Those are formalities.
And you don't have to pay anything. For online applications, you don't have to pay anything.
Normally,
and then in any case, I invite all the members of the bar that if they have any difficulty in getting certified copies, we come in the Chief Justice's court and tell that we are not getting the certified copy. So the energy which we utilize in this making application for dispensing is then passing and
Some procedures. GRC also know that has been followed here in High Court rules. High Court rules, these are the formalities which are supposedly interpret. The certified copy, because that they are now showing the delay. And the online, you can find it. You also rightly said that we can make an application online for getting the certified copy so that it can be, delay can be avoided.
No, delay cannot be avoided. You should not make an application dispense with filing of.
That's exactly.
That is what.
Dispense with the final.
And why should you not get a certified copy?
Well, this will be regular, right? So far as state is concerned.
And if you have already filed, already 4 months have elapsed, you could have filed the certified copy in the meanwhile. This would have become.
This will be regular, right? We'll take care of it.
We have the practice of passing an order that let urgent copy. What is this? Urgent copy you can obtain. If you want an order today itself, we will ensure that that is made available to you. That's a different matter.
Right.
46. 46, my lord, similar to item 40, my lord. Similar to item 40. That is with respect to that education district. There is a delay of 113 days.
You should notice. Well,
Item 47. 47, this is regarding the ex gratia compensation connection with the cyclone Fanny, my lord. So far as the petitioner is concerned, a list of the affected person was prepared by the government. And so far as the damage caused to the petitioner, he was awarded with a compensation of 95. She was found suitable with a compensation of rupees 95,100. Now, initially she was paid 10,000. Thereafter, on the basis of allegations made from different quarters, but a second inspection was conducted, a team of inspection was constituted, and a team inspected the house of the petitioner. And the inspection report, your lordship will find, that is at page 17. Page 17 of the brief. Present condition of the house: one room of Pakka house, good. Circumstantial evidence to ascertain the house condition during the time of cyclone. One room of Pakka house, C is ineligible for the beneficiary. Now, basing on this findings of the inspection team, the rest part of the compensation was not given to her.
When was the cyclone? When was the second inspection?
The
It's supposed to stay in that way until you inspect.
cyclone was on 23/5/2019.
Yes.
The inspection was the second inspection was on 15/7/2021.
2 years.
You wanted them to maintain status quo.
Small matter, I can. My lords. There's a delay of 100 days, your lordship.
We can delay. We have heard the main matter on merits. Also, by the impugned order dated 11/12/2023, passed by the learned single judge, the appellants have been directed to pay to release balance compensation of rupees 85,100 within a period of 1 month. Stop. The facts which are not in dispute have been noted in the impugned order. Stop. The government of the respondent's house was damaged due to cyclone Fani, whereupon the state government of Orissa had declared ex gratia compensation of rupees 95,100 to all persons whose houses were damaged due to cyclone. So accordingly, the petitioner was entitled to receive the said amounts upon completion of inquiry. First off, a sum of rupees 10,000 was released in favor of the petitioner out of respondent out of the said amount of 95,100. Stop. With the grievance that balance amount of rupees 85,100 was not being paid to the respondent. The respondent approached this court by filing a forced writ application. First off, and counsel appearing on for AGA.
AGA.
And an AGA appearing on behalf of the appellant assailing the impugned order has drawn our attention to the inspection report which is which annexure? Which is that annexure
Annexure 2 at page 17, Your Lordship.
report. As regards the damage caused to the respondent's house. First off, the said report is admittedly based on an inspection conducted on by 15/7/2021. That is more than 2 years when the state of Odisha was hit by this cyclone. Stop. Based on the condition of the house as on 15/7/2021, the petitioner has been denied payment of the rest of the amount of compensation, that is 85,000. Stop. He submits that the petitioner was not eligible to receive the amount of compensation as per the report, as the inspecting team found one room of Pakka house in good condition, and the house could be learned single judge in his impugned order has noted the fact that the inspection was done 2 years after the state was hit by cyclone in 2019, and therefore holding the respondent entitled for the amount of compensation has directed the state to pay the rest of the amount, that is 85,001. Next. In our considered opinion, the inspection conducted on 15/7/2021 to assess damage caused to the house of the respondent is irrelevant for the purpose of consideration of payment of amount of compensation. Stop. It is absurd to accept, it is absurd to presume that the beneficiary was required to maintain the condition of the house soon after the damage was caused for 2 years, so as to become entitled to the amount of compensation. So stop. We do not find any legal infirmity in the impugned order passed by the learned civil judge. This appeal is accordingly dismissed.
For admission, item 48.
So yesterday this matter was there, the other side was not there. If you also look to order dated 29/3/2023.
Yes.
Since during pendency of the contempt petition, the opposite party have passed an order on 8/12/2022, cancelling the provisional selection of HIG duplex core house number 2 by nullifying the effect of the order passed by this court. The Assistant Administrative Officer Urban of the State of Orissa Housing Board is directed to remain present in person before this court on 11/4/2023 and file a show cause as to why proceeding of contempt shall not be initiated against him. Then your Lordship kindly come to order dated 24/4/2023.
Yes.
This matter is taken up through High Court. Mr. Kanungal and Senior Counsel appearing for the opposite party files an affidavit pursuant to the order dated 29/3/2023 in court today, incorporating the letter dated 18/4/2023, whereby the order of cancellation of the provisional selection of duplex core house in Unit 6, Bhubaneswar, issued by the authority on 8/12/2022 has been revoked. As such, the same has been communicated to the petitioner by registered post with AD. Copy of the affidavit be served with Mr. B. Rauta, so and so, so and so. And para 3. In the above view of the matter, the opposite parties are directed to comply with the order passed by this court by handing over the duplex core house to the petitioner forthwith. This is the matter on 4/5/2023. Then on 4/5/2023, another affidavit was filed. You also look to that order. Had Mr. So-and-so, myself, and Mr. Kanungo for the opposite party. 3. Mr. Kanungo and Senior Counsel appearing for the opposite party contended out of 3 petitioners.
Just a minute.
I've prepared the dates up to there. I prepared a very short date of events for your Lordship's appreciation. 28/12/2002. Yes. On 28/12/2022, Orissa State Housing Board floated an advertisement inviting application for allotment of 6 number of HIG duplex core houses to be constructed over the allotted area, and pursuant to such advertisement, the present petitioner submitted their respective application. There are 3 petitioners, along with EMD 1,50,000, along with non-refundable processing fee. Then 7/5/2003, for the aforesaid core houses, lottery was conducted on 7/5/2003, and all the 3 petitioners were allotted with core house number 1, 2, 3, 2008. Despite passing of several years, 5 years, when the Orissa State Housing Board did not hand over the possession of the core houses to the petitioner, they, finding no other alternative, approached this honorable court in WPC number 13238 of 2008. On 6/7/2010, this honorable court, by order dated 6/7/2010, disposed of the writ application, directing the opposite party, Orissa Housing Board, to take immediate step for removal of the encroachment and hand over the possession of the core houses to the petitioner, who have been selected in the lottery within a period of 3 months. In 2011, when the opposite party, Orissa Housing Board, did not comply with the order direction given by this honorable court in WPC 13238 of 2008, on 6/7/2010, the present petitioner preferred contempt application bearing number so and so. Then 2018, after lapse of 7 years, the opposite party number 1 filed a so-called affidavit taking a plea of encroachment and pendency of a suit bearing CS number 636 of 2002 filed by PUMS International for non-compliance of the order of the direction passed by this honorable court. 16/8/2022, the aforesaid civil suit bearing number so and so was dismissed by the Civil Judge Senior Division.
Civil suit for what? Other encroachers. Yes.
Yes. Then 8/12/2022, the opposite party addressed a letter on 8/12/2022 to the present petitioner indicating therein that the provisional selection of HIG duplex core house at Unit 6 Bhubaneswar made in favor of the petitioner is hereby cancelled. Then on 29/3/2023, this honorable court directed for personal appearance of Assistant Administrative Urban. Since during the pendency of the present contempt proceeding, opposite party contender cancelled the allotment of HIG duplex core house number 2, thereby nullifying the effect of the order passed by this court. Then 18/4/2023, the opposite party contender, by this order dated 18/4/2023, revoked their earlier order dated 8/12/2022, whereby they have cancelled the selection of HIG duplex core house at Unit 6. That was revoked. Now, 24/4/2023, the matter was listed before this honorable court on 24/4/2023, and the counsel appearing for the contender apprised this honorable court that in the meantime they have revoked the order of
All
cancellation.
right, so let us forget everything. Let us come to the order,
Right, sir.
which has been flouted.
Yes. Yes, sir. Order dated 6/7/2010. Second paragraph, I'm reading. Second.
Annexure? Oh, second paragraph, you have
Yes.
quoted that.
7, no, that annexure also. So page
That is at page 7 of my brief.
Page 7.
Yes, ma'am.
Page 39.
Contempt application, page 7.
Page 39.
Page 39.
Also at page 39.
Also at page 39. Fine. Page 39.
Starts from page 41.
Starts from page 41.
Page 7.
Yes, second paragraph. All the three applicants, petitioner in pursuance of the advertisement issued by Orissa State
Let us
House.
see the operative portion.
Operative portion that you also kindly come to the last portion at page 41. We find from that is important. We find from annexure attached to the writ petition that orders have been passed for removal of the encroachment by help of police has also been sought for by annexure 6.
No, you are reading, we therefore dispose of.
No, I'm reading just before that at page 41. Page
Yes.
41.
Yeah.
We find the
Yes.
we find from annexure attached to the writ petition that orders have been passed for removal of the encroachment and help of police has been sought for by the annexure 6 to remove the encroachment. However, the encroachers have not been evicted as yet. Next line. From the map submitted by the Land Council for the petitioner in course of hearing of the writ application, we also find that the encroachment is in respect of core house number 6, and there is no encroachment so far as core house number 1, 2, and 3. We are concerned with 1, 2, and 3. We therefore dispose of the writ application directing the opposite parties to take immediate step for removal of the encroachment and hand over possession of the core houses in question to petitioner and other 3 persons. Other 3 persons, they were concerned with core house number 6, who have been selected in the lottery, subject to fulfillment of all other criteria, preferably within 3 months from the date of communication of the order. In the event it is not possible to evict the encroacher within the appropriate time, the State Housing Board shall find out as to whether the core house number 1, 2, 3 allotted in favor of the petitioner are free from encroachment. In the event as indicated in the map, if this said core houses are free from encroachment and there is no legal impediment in handing over possession of the same to the petitioner, the same shall be done within the aforesaid stipulated period. Now let's come to the show cause. Show cause, the operative portion of the last paragraph. They said that whatever illegal impediment was there, that has already been over, and will now take steps. Necessary steps have been taken to hand over. Let's look to page. That is that page.
So these 3 core houses were allotted.
Yes, 3 houses. 6 houses totally allotted. 3 petitioner and 3 others are others. We are not concerned.
So you are first is petitioner number 1.
Petitioner 1, 2, 3. I am for all 3 petitioners.
Core house number 1 was allotted to whom? It is either petitioner number 1, petitioner number 2.
That is between 1, 2, 3. It was allotted to 3 petitioners.
So
Exactly.
which house to which petitioner?
That has not been mentioned. It has not been.
Rautri, there's one affidavit which they say that the core houses have not been constructed. That is not correct.
That core house they have not yet constructed, but the land is still vacant.
So how will they hand over core houses if it has not
So
been
you are
constructed?
entitled for house or land?
We are entitled for house and also as well as the land.
And
They said, Your Lordship, just kindly glance to the so cause. It was just paragraph 32, as page 58. Let's look to that. Just I'm reading. In view of the above legal orders, they said that suit was filed by somebody. So that suit has ultimately dismissed. The appeal has been also dismissed. So they said in 2018 that in view of the legal hurdles, till date the encroacher could not be evicted, as a result of which the order passed by this honorable court has not yet been complied with in spite of best effort. In the meanwhile, necessary steps have been taken by the contemner to vacate the above expired vacate order passed by the land civil judge. The encroacher has made all hand twisting methods in order to obstruct the contemner from exercising statutory right for his eviction. In view of the judicial pronouncements, hands of the contemners are now tied. Due to above bona fide reason, the order of the honorable court could not be complied with, for which different begged unconditional apology. But subsequently, if the suit has been dismissed and that has been enclosed at flag A. But the contempt is three parts. But the contempt is, you know, again look to that.
No, then just come to the last paragraph of the order.
Yes, I'm reading now. We therefore disposed of the writ application, directing the opposite party to take immediate step for removal of the encroachment. Now encroachment is over.
Please read it.
Yes, sir. And hand over possession of the core houses.
Core houses are not there.
Well, exactly that I have to take instruction. In fact, I was told there are some core houses, but that is abandoned like that. But exactly I can't say unless I file the affidavit.
If the said core houses are free from encroachment, houses are not there.
Well, just I take it. Well. It occupies this. So for the core house, construction of core house, I have to, I'm not sure. I have to keep it.
Contempt.
I have to take the instructions.
Where is the contempt? This is 2011, man.
In fact, if you also see the last order, of course, by coordinate bench, they have stated that we are giving them. You also look to that order dated, the final order, last order, dated 4/5/2023. Which one? 18/5 is the last order, but 4/5 will also look to that. They have said, if you also would see that, Mr. Kanungol's second paragraph, Mr. Kanungol and senior counsel appearing for the opposite party contended that out of three petitioners, petition number 1 and 2, namely Dr. Devaprasad Sahu and Santosh Kumar Rao, have already taken back their amount by encashing checks. It is not a fact also. One of the person who has taken, but they have deposited again. That amount has been deposited and transferred. One. But so far the other petitioner also see that. So far the petition number 3, namely Oleg Chandra Padiar is concerned, and now so far the Oleg Chandra Padiar is concerned, opposite parties are trying to find out the way to resolve the issue, meaning by they are discussing with the government to give an alternative house to him so that the very purpose of core house scheme can be achieved. So but contempt, because there are three parts in the order. First part is eviction. First part you also see the earlier order. In the earlier writ application that I have just now placed, we find from the annexure attached to the writ petition that orders have been passed for removal of the encroachment and by help of police has also been sought for by the annexure 6. Then the second part is this: the Honorable Court said that we
and
find
there was suit pending.
That suit already been disposed of.
Now disposed of.
By that time, the suit was filed subsequently.
No, when the order of the High Court was passed, whether the suit was filed subsequent to passing of
subsequent to the suit.
All right, what happened in that suit?
That suit was dismissed.
Whether any interim order was passed?
There was an interim order.
There was an interim order.
There was an interim order, but that interim order was vacated subsequently. That was vacated. After some time, it was vacated. That is now, encroachment is free. Dismissed. Appeal was also dismissed. Dismissed. So that's right. But now at the present, there is no encroachment.
At present is different thing. When the order was.
Well, that is why they say, you also kind of have a, what this court said. This court said that we therefore dispose of the writ application, directing the opposite party to take immediate step for removal of the encroachment and hand over possession of the courthouse.
Courthouse is not there.
So thereafter, in question to the petitioner and other 3 persons who have been selected in the lottery subject to fulfillment. In the event it is not possible to evict the encroacher within the appropriate time, the State Housing Board shall find out as to whether the courthouse number 1, 2, 3 allotted in favor of the petitioner are free from encroachment. This is, we are concerned with 1, 2, 3.
There is no courthouse.
Sir, I have to, so far as that courthouse is concerned, I have to take instruction. I can't say firmly that there is no courthouse. Plus, kindly keep it to tomorrow. I can also file an affidavit. Because petition number 3, in fact, yesterday he had, I could not take the instructions.
All right. We'll take. Come on. Tomorrow we will see.
Man, can it be day after tomorrow?
Yeah.
Item 49.
Monday will. And who is there for the other side?
Nobody's good. Yesterday nobody had appeared. Yes, that is why you were skipping.
There is no representation on behalf of the contenders. Mr. Kanungo was appearing.
Yes, he appeared subsequently, but Mr. Mishra was, KK Mishra was appearing earlier, but subsequently appeared. But
the contenders will face contempt. Why should he not come? Okay. Can you inform him?
Well,
You ask him, please ask him.
Kindly see order dated 24/4/24.
49.
Your lordship had directed me to give a representation and come. I have not yet received any reply from them. Lordship may kindly see that order for paragraph 4.
Paragraph 4 of the petition.
Of the order, 24
Of the order.
24.
20.
24/4/24,
Yeah.
order number 16.
Yeah.
Learned Senior Counsel representing IDCO has submitted that chairman cum managing director shall consider if any such proposal is made. List this matter on 19.6. Let a representation proposal be made by the petitioner to the chairman cum managing director IDCO within 1 week from today. This court expects that the chairman cum manager shall take a decision on the petitioner's proposal within a week. The lordship remembers that matter where I had offered that I can take it at the present price. That only. So I have given my representation.
I am there for the OP number 2 and 3, my lord. I could not obtain instruction, my lord. I need 2 to 3 days, my lord, to obtain instruction, my lord. In any day next week, my lord, I can do.
Pursuant to your lordship's order, I have made a representation. I have also given that chart also.
There are 3 paragraphs. There are 3 paragraphs. There is a mistake. How to? Sentence paragraphs. There is a printing error in typing error, typographical error in paragraph in the order number 16 dated 24/4/2024 in as much as the we'll see it. When?
Lord, any day next week, I will obtain instruction.
Lord, may I pray one thing, Lord? Let them give the affidavit or whatever the reply, and 1 or 2 days for me to check with my petition. So lordship may post it 1 week after.
1 week.
After, and 1 week, within 1 week, let them give that reply.
Let this matter on 1 week. so as to enable the parties to effectively act upon the observations and the order dated 24/4/2024. Interim order to continue. Interim order was the interim order shall continue in the meanwhile. What is the interim order?
Interim was status quo.
No, I am not, but they, if they allot and many constructions, because I have already made certain constructions. So that is why if they make the allotment, then your lordship is putting it to
1 week.
1 week after. So I only want that, let the reply, I have to check up, that's.
It is expected that in the meanwhile, the IDCO, what is that? IDCO shall file an affidavit after serving a copy thereof on Land Council for the petitioner.
A. Mishram. On behalf of J. Mukherjee.
What is this? TK International is a hotel? Hotel or hotel?
Hotel.
Is it a hotel or
To be constructed.
Item 50.
Item 50, my lord, on behalf of Mr. Naresh Chandra Sahu, I pray for next week, my lord.
I am appearing for
Mr.
opposite party.
I am for the opposite party 1 and 2.
Mr. Naresh Chandra Sahu is not well.
What happened?
He is ill.
What?
He is suffering from fever.
Fever?
Hmm.
Since when?
Since when?
Since yesterday.
He called me also, my lord, in the morning. He called me also.
All right. As requested on behalf of the this appellant, appellants, there are how many? Appellant? Yes, we'll list these matters on. With these appeals on 1 week. Yes.
Item 51. Item 51, my lord. On last occasion, I have taken time, this matter will be conducted by an advocate general. My lord, now.
So what is the matter about?
That is the matter regarding that a contempt matter. Order was passed by the state administrative tribunal. As per our pleadings that we have complied that order, but in the disposal matter that direction has been given to comply that order, and that is the only that we have said that this order is beyond the scope of the order passed in the earlier original application. So matter is to be argued by. I have taken
genuine prayer.
I have requested also. I have taken consent of my senior.
Of the apparent this matter on 2 weeks.
May I pray, my lord, 3 weeks by
3 weeks.
my lord.
All right. Any objection?
No issue. No. Also obliged.
Item number 52.
$52 million. On behalf of Mr. Mishra, my lord, Senior Counsel Mr. S.P. Mishra, my lord, I only pray, my lord, let it be taken up next week. And lordship may kindly fix up a time, my lord, so that it can be taken, my lord. Having some personal difficulty, my lord. In this case, my lord, I am from 52. But in this case, I am the respondent for my lord. They have filed a private case. Respondent, my lord. There are several occasions. They must. So let it come the next week. A date, time may be fixed, my lord. Either 2 p.m. or in orders, because I have filed a miscase for vacation of interim order. That may be listed in orders. The heading of. Yes, my lord. They have filed an IA. They have filed an IA, my lord, the vacation of that day. Let it be taken up next week, my lord, because Mr. Mishra is having some. Lordship, because today also is there, my lord. Only I pray the item 79 is going on in court number 3 is engaged. Only, or else let it be passed over or tomorrow. No, my lord. That is why I have been instructed to take time, my lord. That is next week, my lord. Yes, it is. Okay. 2 p.m. or in orders, my lord. Let it come 2 p.m. or in orders, my lord.
Item 53.
May I please, my lordship. My lords, on last occasion, this court directed to file an affidavit in compliance with the order dated 15th of March 2022. But no affidavits were received.
On item 53, my lord, I am appearing for Sri Jagannath Temple Administration. Counter I have already filed. A direction was to file an affidavit indicating the number of disposals made in the meantime. Pursuant to section 16(2) of the amended act, my lord. Because section 16(2) in the amendment act of the Temple Act is under challenge. The uniform policy, my lord, known, my lord, we have formulated a uniform policy to dispose of the DT's property, my lord, in pursuance to section 16, that is alienation of the DT's property, my lord, section 16 of the Temple Act. He is the petitioner.
I'm for the petition. I'm a social worker.
Or
My lords. But here there is an ordinance passed by the government. We are challenging ultra high. Yes. Yes, ma'am.
Yeah.
no, it is
Followed by
acted upon.
rules.
How did
Yes. Yeah, we
it has
have
become a law, my lord?
It has,
Now,
we have
so
acted upon that.
Yes, so accordingly amend that.
Yes.
Yes,
Yes. Yes. It was look to the 16(2). Yeah. Yes. Yes.
Section 16, my lords.
16(2) now. Sixteen is alienation of temple properties.
It's about alienation of temple properties. You were challenging which provision?
16(2), my lords.
Into
Yes, my lords.
what is there in the
There is a change by passing an ordinance. There is a amendment by passing an ordinance. It's in Annex 2, my lords. May I read?
Not easy disclosure.
You were challenging this ordinance.
Yes, my lords.
Where is the act? The council you are saying.
But subsequently act it is enacted. Page 15 is the Gazette Law Department notification. Page 15. That annexure 2 is annexed to the writ petition, PIL. Yes. Page 15. Yes. It is.
Annex 2 is the ordinance.
Yes, it is. Yes. Ordinance, yes, madam. There are lots of. Hey, we have acted, yes. That he's saying that we have. But
How is this illegal?
My lord, kind of glance on page 7. I've quoted that section 16, subsection 2. It says, save as otherwise expressly provided in this act, no immovable property taken possession of the committee shall be leased out for more than 5 years or mortgaged, sold or otherwise alienated, except with the previous sanction of the state government. So before selling any property, there must be sanction from the government. Now by passing an ordinance, it was changed. Now by annexure 2 at page 15, it reads as, save as otherwise provided in this act, the immovable property taken possession by the committee may be leased out, sold or otherwise alienated by it, subject to such condition and exception, and in such manner as may be prescribed. Now this gives exclusive power to the committee.
Property.
Not for challenging the law. Whether he had the competence or not.
Governor has the competence. But but my lords, if you look into the scheme of the act, it is not allowed. We are challenging that. I need to explain that. My lord, this amendment exclusively gives power to the committee to lease out, sold out any property. Now, no sanction of the government is required. Now, previously, the sanction of government is required. Now, my contention is, if you look to the scheme of the act, it is not allowed. The power distribution is with the government as well as with the committee. I need to explain. I need to file a written note also. It was with me, but actually I left it out in the bar, I think. Forget in the bar actually. I'm sorry for that.
If your lordships.
You vested, there is nothing.
But my submission was that there is specific direction that is not complied with. Yes, my lord.
What?
My lord, on 15th of March 2022.
15th of March 2022, the ordinance was there.
Yes,
but
my lord.
now its life has expired.
But they have entered into some transactions.
Challenge those transactions.
This was the direction. You provide those in para 5. I could have challenged that, my lord, but still.
Shall be subject to result of writ application.
My lord, I will file an affidavit to that effect. Within a week, my lord, I will file affidavit, provide the data, how many cases we have disposed of in the meantime. No, I have not, my lord. It is available with me. I'll file it, my lord, because the officers change in the meantime. So I'll file it. Within a week, my lord, I will file. Well, I'll file it, my lord, within a week, my lord. Within 2 days, my lord, I can file it. Because, it is available with me, but I cannot file because he has transferred. The officer in the meantime has transferred. I have filed the counter immediately, but in the counter, the specific direction was to give the details data. That was overlooked, my lord. That's why I have not filed, but I have to make an affidavit to that effect. I filed the counter immediately.
Well, the direction was, may I read? The counter affidavit
Counter
filed
affidavit I
by
have
the opposite parties. Yes, my lords.
Well, temple affidavit, administrator, temple administrator is to file the affidavit, my lord. My lord, affidavit is, my lord, if you see data is available with me, I have to put it in shape of affidavit, my lord. I have to only put it in shape of, my lord, I am not, my lord. I have to put it in affidavit, my lord. Only that officer is not available, so I have not filed. In the meantime, he has transferred. So I cannot file. I will file it within 2 days, my lord. And this is the temple's properties. DT will be the ultimately DT will suffer. DT will suffer, my lord.
What is this? Please don't make it suffer.
I am sorry. I am sorry, my lord. But my only.
DT will make you suffer.
I humbly request your lordship to allow me at least.
If you have so much space.
I pray only 2 days. I beg apology for that.
Who are you?
I am for the temples. A Subrat Satpat, my lord, for temple administration. Administration. For OP number 3.
3 and 4.
3 and 4.
This application was taken apart on 15 feet 2000. Notices were directed to the party. Was specifically directed, the only parties were specifically directed to the file they were entitled to the only of the also mentioned in the order that all actions taken pursuant to the amended section 60 rectification of the Jagannath Temple Act 1964 would be subject to the outcome of the present. So, paragraph 5 of the same order, it was clearly mentioned that the opposite parties specifically indicate the details of the transaction entered into pursuant to the amended section. So, it is noted at this stage that section 16 related to was amended by and Parliament. On 9/1/2022, published in Orissa Gazette. The state order
requiring the opposite party to indicate details of transactions has not been transacted and no affidavit has been filed on behalf of opposite party to see
Three,
only
three, 3, 4,
first people and
347, temple.
from the other sheet it transpired that
My lord.
have you filed any affidavit?
Yes, my lords, they are filed.
Counter affidavit I have filed. Yes. Counter affidavit long since we have filed.
So the affidavit was filed on behalf of the response from the state. He and sir. He and sir. He and sir. He is of transaction. And the as mentioned in paragraph 5 of the order dated 15/2022 was not incorporated in the affidavit. Again on 24/1/2024. Today, in order to be set, the form for the party number P and 7 were required to give the details of transaction from the contractor of one big time of the party number P and 7 to file an additional affidavit adherence to this both orders passed on 4/1/2024 disclosing the details of transactions related to pursuant to the limited subject. Subject to payment of cost of the $15,000 to be deposited in the account of state. Which are state figures are required.
I am sorry, my lord, that cost may be your losses may. I beg apologies for my cost may be. Just may waive out the cost, my lord. I'll file it within 2 days, my lord. Tomorrow I can file also, my lord. Status are available, my lord. Have you misunderstood, my lord? I'm sorry, my lord.
Item 54.
Pardon, my lord. The lordship fixed to item 52 to 26. I have personal difficulty. Let it come 27th, my lord. My learner friend is there. On 27th.
Item 54.
Wait, please, your lordship. And in this writ petition, challenge is to the decision of the government regarding the transfer of a primary school to the campus of a high school, my lord. The school name is Kisorganj Primary School. It houses students from classes 1 to classes 5, my lord. The government has decided to transfer the school to the campus of RD High School. And the reason for that is that the school was situated adjacent to the highway. Due to the widening and expansion of the highway, a portion of the school was demolished, my lord. So there was requirement of reconstruction and renovation of the school, my lord. So for the renovation of the school, that particular school was decided to be transferred to the campus. No, my lord.
We are education secretary.
No, my lord.
Are we here to decide where the?
Well, the villages are before your lordship because the children of these villagers who go to the school, they have to cross a national highway, my lord. Because
Yes. Yes, I have filed that there is an affidavit, your lordship, you can get it from filed by on 17/2/2024 that with the photographs. Yes.
Yes, we have constructed the.
Well, underpass will still require the children who are between 5 to 10 years to cross the highway, my lord. This underpass will not ensure their safety. The safety of the children is at stake because it cannot be guaranteed that these children from 5 to 10, the parents will accompany them. Because also we have made several, these villagers, also the school committee of the primary school as well as of the high school, they have made several representations that there is a land adjacent to the old school and the new school could be constructed on that land so that these students, these 5 to 10 year children will not be required to cross that highway, my lord. My lord, because this is a 4-lane highway, my lord. The underpass will not ensure that safety. Therefore, my lord, also, my lord, the service road below the my lord, still
Because there are, and this school is established within that high school and 220 meters.
My lord, there is a land adjacent to that. Also, my lord, the distance will be increased from 1 kilometer, above 1 kilometer, my lord.
My lord, on behalf of NHI, my lord, on behalf of Mr. Umesh Mahanti, I have filed the counter further affidavit. In the meantime, we have National Highway is constructing the school and constructing the overpass.
Moreover, my lord,
the photographs are there in the further affidavit.
Moreover, my lord, the demolition was 2 years back in 2022. Since then, they have filed the photograph. This is the stage at which the construction is at. The students are, these small students are continuing their studies in that primary school. No measures have been taken to even to ensure their studies in those dilapidated buildings, my lord. School has also not been constructed, my lord.
Yes, construction is going on. My lord, the photograph is at
Photographs.
9. It is on 17th February. 17th February.
And they have filed that affidavit, they will construct the building.
That is the construction, building construction is going on and overpass also is going, also has been constructed and peripheral activities are going on. Underpass, sorry. It will take time because monsoon is approaching, not otherwise it will.
How much time will it take?
My lord, can I? It may be after monsoon, my lord, that the development, I said file a further affidavit. No, my lord, it can.
Now, this affidavit was filed in February. They have
in the meantime,
this under
construction
process.
must have been completed.
At the plinth level, they have given that photograph
By that time.
Plinth.
My lord? Now that has been demolished. The new school has been constructed in the peripheral building of RD school.
Minor.
Old school. Partly it has been already
Boundary
because
work.
after acquisition, unless this house is now school is constructed. Yes. By February it was all up to plinth level. But now I can also file a further affidavit of what development has been made because 4 months have passed in the meantime.
So what is more important, national highway or education of children?
Education of children, both the and the development of the also road, both the by the side
What
road.
is more important? This
Life safety of the children.
no education. Compare between the national construction of national highway and education of poor children.
That is too much.
What is more important?
Education is more.
Should have stayed the construction of national highway.
No, my lord, construction is going on. Construction,
We can take construction.
my lord, it is, there is, that is not the objection.
That cannot take place at the cost of the education of children.
My lord, for that reason, National Highway is constructing is the school. Let me file a further affidavit, my lord.
When was the school demolished?
That was
29/11/2021.
And we are in 2024.
let me file
No,
a
there was
status,
a
present status. I
interim order was there. Interim order was there, that was vacated in 2023. Interim order was there. Yes. No, yes. You know, that was the
Status quo, man.
status quo that was vacated on 29/11/2022. Well, thereafter they have proceeded.
Thereafter the
That
construction.
NHI is to construct that building.
Yes.
That within that.
You will have to show the court.
Yes, ma'am. That.
They are in a position to go to school now.
Yes, ma'am.
As on day.
Yes, madam.
Every day is important for a child.
Yes, ma'am. That assurance, that affidavit, at least to that effect, an affidavit will be filed by the state as well as the NHI that regarding that construction of building. The construction of the building is the work of the NHI. So they will file an affidavit, the progress of that building, and I will file an affidavit to that extent that how safety measures have been taken. That. Yes.
Must be repaired.
Yes, ma'am. That affidavit I will file. No, that there will be no break in the study.
No concern.
My love, we are no way concerned because only our concern the studies of the children. Yes, that our concern is the studies of the children. My love, that is our lookout. My lord, we have to see their safety and the yes we. You'll also say DO will file that that will suffice. My lord, operating part number 7. DO Angul. District Education Officer Angul. District Education Officer Angul.
Or the function of the food living or construction of the education of the children studying in which school?
Isurganj Primary School.
Which school?
Angul, man.
And whether the children studying somewhere without any hindrance. The affidavit to sign on behalf of the NHI. The NHI will be required to disclose in the affidavit as to in what period the new building of the school can be constructed. And the work of
Well, item 55.
55 minutes. I'm praying 2 weeks time to file a rejoinder that state opposite pact number 4 has filed a counter in the meantime. That with that counter I'll file a rejoinder manner. Last whatever. Maybe file is to be.
24 to 2022. My lord.
Because here the fact remains only one question is involved, my lord, that the annexure 1 is the cancellation order of the Tahsildar for cancelling the tender, my lord, that my sole question that he cannot cancel, only collector can cancel, my lord, pursuant to the rule that collector only cancels the said tender. Here challenging the cancellation of tender, the petitioner being the successful bidder, without giving any opportunity of hearing or assigning any reason, they have cancelled the tender. But the jurisdiction has provided to collector, not to the Tahsildar. That is my sole question. Collector has annexure 1 that Tahsildar has cancelled the tender. The rule provides, my lord, sub rule 16 of the rule 27, that any bid matter is relates to. Annexure 1, let's see, may kindly have a glance. Tender is annexure 2, my lord. That is a land side, sand side, man. For 5 years long-term release, that is 2022, but 2 Cyrus, it has been there.
My lord, BD was cancelled, my lord, only because he is the single bidder. That is the reason.
No. That what my friend is saying, there are 2 bidders, my lord.
And one was rejected for non-submission of the EMD. That's why he became the single bidder.
Single bidder, and you cannot cancel because you have to recommend to the collector. Collector can cancel because the price is not up to. That is the rule, my lord. So you cannot go beyond the rule, my lord. That is my case. Of rule 16 of the rule 27, my lord.
Tahsildar. My lord, he has the right. He has right to cancel.
Because what my friend has stated in the counter. All right, I understand, my lord. The rule provides, my lord. I'm just reading the rule, your lordship, to take the collector or the conservation of the forest, as the case may be, shall have power. That is, shall, what is that, my lord? Shall have the power to cancel the bid, duly recording the reasons thereof, if he is not satisfied with the publicity participation of bidders. So participation of bidder is concerned. What my friend has suggested that only one bidder is there. So even if it is participation of bidders, tender has been issued by the Tahsildar, my lord. Under the rule that collector is the authority, my lord.
No, Tahsildar is the authority.
Yes, my lord. I understand, my lord, that Tahsildar is.
Where is Tahsildar seat? The collector has the power to test.
2%.
Well, found to be defective. With the different case that the price quoted by him was the right. And therefore he was substituted. The Tahsildar by notice dated 10/9/2024. What is the date?
Cancellation.
Till 11/2022.
Has cancelled the state tender notice by advertisement number 32 selected. The state tender notice for option of the there are questions. The notice of cancellation of tender has been put to challenge by the student. With the application. So, that's when of the and permitted that the does not have the restriction. Cancel the tender notice as such are invested in the rule.
That sub rule 16 of the rule 27, ma'am. Sub rule 16 of the rule 27 of the
State of something. The council hearing on behalf of the opposite parties and however subject that the Tahsildar who had issued the tender notice had the authority to resolve this thing.
that is there.
13, ma'am.
That there is only either one of whom one of which permitted by one of the bigger contribution. And thus the internet became the single of that account was decided to take it by the circular to cancel the tender. the submission. Depend on behalf of the petitioner that only collected as the government to control it. With reference to Rule 16 of Rule 28.
27. 27. Yes, ma'am.
For the reason that the state power is vested in the collector in case he is not satisfied with the publicity from a participation of the bidder and amount of additional charge quoted. So, in present case, in present case, we find that in was 10 of the tenders of the tender process was specifically that the tender could be the answer
Plus 13. 13. Ma'am. Ma'am.
the facts of the
Obliged.
Item number 56.
May I please, madam? The state was directed to file an affidavit. This matter relates to the missing keys of Ratna Bhandar matters. Missing keys of Ratna Bhandar matter.
No, it's not, it's Ratna Bhandar, it's
So Justice Raghuveer Das commission. report that we have.
it's different, Lords. And I had filed an affidavit on 5/4/2024, Lords, wherein the
I have not
lordship,
received any copy.
your lordships, it has been decided to place the same before the new cabinet, which will be constituted of the results of the Odisha Assembly. Now, in view of this affidavit, your lordship is there with the lordship's record. Affidavit, which was dated 5/4.
for 2024.
Yes, Lord. Lordship may kindly come to paragraph 3. That the Justice Raghuveer Das Commission, which was constituted for inquiry into the missing and non-availability of the keys of the inner chamber of the Ratna Bhandar, Sri Chanpur Puri, has submitted a report to the state government. Thereafter, the said inquiry report has been examined and in compliance with the provisions of the Commission's Inquiry Act 1952, it has been decided to place the same before the new cabinet, which will be constituted after the results of the Odisha Legislative Assembly election in June 2024. It is submitted that the inquiry report shall be placed before the cabinet at the earliest instances. So in view of this affidavit, it can now be placed before there is no embargo or.
My lord, so one cabinet meeting is already over. So they have not submitted any report to the cabinet.
Directly cabinet to take up.
No, my lords. The court cannot.
5 years and 5.
Well, it's based on the separation of power. So
Power.
until and unless there are some gross illegality, the court cannot direct.
Following statement that
Item number 57.
May I please your lordship? Lordship, I am appearing in this.
Yes. What do you want?
Lordship, may kindly adjourn the matter.
Yeah. What do you want?
Lordship, adjournment.
Adjournment?
Yes.
We decline. We decline your prayer.
Lordship may be taken in the first week of July.
Sorry.
His mother is not well, so he is in hospital. So that is maybe taken after a week, Lordship. 28th to 27th of June of this month.
Yeah, this is. Maybe of last indulgence. This is how repeated adjournments have been granted in this case at the instance of the petitioner's counsel. So by way of today also, a prayer is being made for adjournment on the ground of illness of learned senior counsel.
Mother of
Yes.
senior counsel.
Illness of mother of Mr. D.K. Rath. Top. By way of last indulgence, the matter is adjourned to 1 week. Stop. In no circumstance this court will grant further adjournment and shall consider dismissing the writ petition for default if another adjournment is sought or there is no representation on behalf of the petitioner. Yes.
Much obliged.
Item 58.
With effect with counter.
58, your lordship, the matter has become infructuous and the, if a counter can be seen, your lordship, the canal has already been repaired and the photographs are there. To that effect, your lordship, showing that the canal has already been repaired. So the matter is infructuous, your lordship.
So it was for repairing that canal?
Yes, your lordship,
That
they
has been
were.
done.
Yes, your lordship.
There is no representation on behalf of the petitioner. Petitioner. Of this writ application. So PIL
Yes, your lordship.
in the nature of public interest litigation has been filed.
Page 8 is the prayer.
Hmm?
Page 8 is the prayer. They said they already repaired it.
Seeking direction for repairing / construction of CADA canal from Vidyadharpur Gram Panchayat office to Gandhanapada, Motra Chak. That is the interception.
In Vidyadhar Gram Panchayat, there should be an office. I'll check.
In Vidyadhar Gram Panchayat. No, from Vidyadhar Gram Panchayat. Oh, Vidyadhar.
Under Vidyadhar.
From the seeking direction. Or just create a canal under Vidyadharpur Gram Panchayat of
Office.
Jagat Singhpur district.
Yes. I'll do it.
Stop. An affidavit has been, counter affidavit has been filed. A counter affidavit has been filed on behalf of the opposite parties stating
Paragraph 8, they have stated.
in paragraph 8
Page 15.
as under. Full stop.
Okay.
Quote कर देना पर. In such view of the matter, this, in view of the statement made in the counter affidavit, it appears that this writ application has become infructuous. Stop. It stands disposed of accordingly.
Item 59.
My lord, in this matter, we have received the counter. My lord, kindly grants 2 weeks time to file return.
So when did you receive?
My lord,
Did you receive the counter?
February.
February 2020.
2 weeks. My lords, we have received the counter some 22nd of February 2024.
Shifting of IMFL shop.
Actually, Mr. Das had some personal problem.
Is there any interim order?
No interim order.
As requested. Yeah. We are seeking at the discussion on behalf of the petitioner. This matter on 1 week.
You wanted to file counter, you don't want to file counter.
File counter.
You have filed.
No file. Filing.
Time will not be granted. Earlier time was granted.
You are committed.
No, he is probably
Option number
P5.
You had filed a caveat petition, no?
Months.
So on February 2024, you had been granted time to file counter.
Option or sir.
You were asked to file counter.
So you will prepare your counter affidavit on the basis of his counter affidavit. Hmm?
Item number 60.
To say his usual Mr. B.K. Behra is not there.
You have
Or
to
not
dispose of. Complied.
complied with. Not.
He is not-
It is stated by Mr. Pankaj that this court's order violation of which has been alleged in the present contempt application has been complied with. So the contempt application stands disposed of accordingly.